Oh, did it hit live? Am I live? June 18th, 2025, a jury in Norfolk County, Massachusetts, delivered its verdict in the Karen Read murder trial, actually the retrial. Not guilty on murder, not guilty on manslaughter, guilty on OUI. And that night, according to the complaint we're going to break down tonight, over the next couple hours, Karen Read goes to a celebration dinner. And at that dinner, she takes a photograph with a man named Aidan Kearney. But I fucked that up all night. The guy known online as Turtleboy. The guy who for 2 years ran the most prolific online campaign in the history of Massachusetts legal media, calling the witnesses in her case cop killers. Kearney posts the photograph on X. The caption reads, quote, "Last two I'd fuck with." Here's a line from the complaint that gets us. And I'm talking about Ali and I. Paragraph 110, the complaint alleges that Kearney acknowledged that he and Read had spoken about recreating that picture with the same caption over 2 years earlier, meaning if the allegation is accurate, before the first trial. If you thought the Karen Read saga ended on the courthouse steps in June of 2025, and I'm talking about legally, not the drama, according to this complaint, it's just getting started. Yesterday, April 16th, 2026, 4 people walked into a Barnstable Superior Court and filed a 50-page civil complaint. Jennifer McCabe, Brian Albert, Colin Albert, and ATF Special Agent Brian Higgins. The 4 witnesses, the criminal defense spent better half of one trial and a little bit in the second trial telling 2 juries that they were the real killers of John O'Keefe. We're getting into tonight. This is Defense Diaries. What is up, everybody? Hello, beautiful humans. I'm Bob Motta. This is Defense Diaries. That beautiful and brilliant woman is my co-host, Ali. What's up, girl?
Hey, babe. Hey, all.
So the big defamation complaint hit.
I mean, it's a thing.
It's a thing. I've been avoiding Karen Read content for a hot minute. We didn't even cover the first civil complaint, but this one, it's interesting. It's got a lot of moving parts, and it's so closely connected with the criminal case that I felt compelled to cover it, because ultimately, at the end of the day, should this thing make it through anti-SLAPP motions to dismiss, motions for summary judgment, and makes it all the way to trial, you could bet your ass that entire criminal trial is going to be retried in civil court with a much lower burden. And that burden is on the plaintiffs, not the defendants. So it's interesting.
I don't know. I just have to say that I am shocked that they found a lawyer to file this thing. I can't imagine. I got to clear my throat.
Yeah. And it's not like some schmuck. It's Hinckley Allen out of Boston and Koskoff, who, they won that huge Alex Jones, Sandy Hook verdict, $1.4 million. So
I just can't imagine they would take this on contingency, because their whole foundation is like ridiculous. It's, I would say, ridiculous.
Well, I think that it's a high publicity case. We don't know that they took it on contingency. You would think, you could take cases on contingency, and you can obviously take them on what we used to do, which was a hybrid, where, you're like, look, you're going to cover the cost talking to your plaintiff.
Right. So that's what I'm assuming. This is probably that, but they'd probably want a shit ton of money.
Probably.
Even for a hybrid.
Yeah. I guess it depends on you're the one who brought it up off camera with me about the concept of it being high publicity.
Right.
But you were really kind of talking about from Aidan's side more than I think the plaintiff side when you made that comment. You know,
Well,
'cause
are
at this
those
point,
local lawyers?
well, I know that Hinckley Allen's out of Boston. Koskoff, they're probably, I think they're pretty big, so they probably handle stuff all over the country, like most big plaintiffs firms do. So yeah, it's going to be an interesting thing. It's going to be an interesting thing. So the way that we kind of want to handle this tonight is, I think we're going to go through a bulk of the complaint. I know many of you were probably on Melanie's channel earlier today, and I know that she read through it. I think we're going to read through it again. We'll probably skip some things that we think aren't as pertinent as other things. But I thought that it probably made the most sense to talk about it in terms of the things that I think, and you probably think, are going to happen first in this before the real litigation in this case starts, if it makes it there. And, kind of the first thing that I think is going to happen is that definitely Aidan is going to file an anti-SLAPP motion, potentially Karen. And, ultimately at the end of the day, whether or not those will prevail or not is debatable, but I think it'll be important for people to understand it, because in terms of Massachusetts law, I had to familiarize myself with kind of what the burden was there, and what you had to accomplish in order to be able to win on that kind of motion. And it's interesting because you're having to stretch it a little bit in order to get it to where you need it to be in order to prevail on it. But so before we get into the substance of the complaint, that's what we're going to do. We're going to go through anti-SLAPP, and then we obviously want to talk about the fact that it was filed in Barnstable. That's clearly venue shopping. And it's evident, and it's the right move if you're the plaintiff in this case. You don't want to try this thing anywhere near Canton, because
I would move for form of non-convenience like that no one else lives.
Well, we're going to get there. You're jumping ahead. I'm just talking about, we're going to handle that after it. But yeah, I'm talking about from the plaintiff side. You don't want it in Canton for obvious reasons. Everybody in that town, well, not everybody.
Right before we started, I just decided I'm starving. So I'm sitting here thinking about, should I order a pizza to get delivered while
we're turning this into an audio podcast, man. Like,
sorry.
Keep it clean. Keep it clean. Darren, you're going to have to take that out.
I didn't know that. Okay. Sorry.
Yeah. Yeah.
Guarantee you it gets in with that. No, just kidding, Darren. I don't think you would let that happen. All
right. So let's kind of start with the anti-SLAPP stuff. And
all right. So want me to give a summary of the act real quick?
Yeah.
So the statute provides like powerful early dismissal tools that can significantly benefit two categories of defendants in a civil lawsuit tied to, like what we have here, a high-profile murder case. One, the criminal defendant who, during the underlying criminal proceeding, publicly accused the civil plaintiffs of committing the murder and framing her. And two, the journalist, Aidan, who covered the case and forcefully argued the same theory. I think that both defendants can file a motion to dismiss, which automatically stays all discovery and must be heard expeditiously. So under the controlling framework, which there was a new 2024 case, I don't know what's going on, but this me needing to clear my throat.
Yeah, it's weird.
The defendant's statements made in connection with their criminal prosecution are quintessential, what's called petitioning activity. Good talk, babe.
Okay. Well, let me just tell people what it stands for. So the acronym SLAPP stands for Strategic lawsuit against public participation. So that's what the SLAP stands for. So I was trying to think of a kind of a way to explain it. So imagine that you own like a real estate development company and that you want to build some massive shopping mall in a residential neighborhood. And the people that live in that neighborhood are like, what? No, you're not doing that. Well, like, no way. It'll destroy the entire fabric of our neighborhood to have some monstrosity of a mall there. So the neighbors get together and they're like, you know what? We got to show up at planning board meetings. We got to show up at city hall. We've got to sign petitions. We need to organize. We need to stop this from happening. And that, you know, is like standard civic participation. And so then ultimately, you know, those people are out there, they're talking shit about the builder, saying, you know, that they're awful, you know, defaming them. And then ultimately, they file a lawsuit against them. Okay. And I'm talking about the people. And I'm talking about the builder, the real estate company files suit against them for defamation and their, you know, interference with business relations, civil conspiracy. And they don't care if you win. And I'm talking about the people. What they care about is making those folks that live in that neighborhood defend the claim, to make them pay for the cost of litigation, which is very, very expensive. It just is. So the lawsuit itself becomes the punishment. And when we get to the complaint, if you're reading it carefully, you can see that there are a lot of elements of that in the complaint that I think if you were to able to ask McCabe and the Higgins and the Alberts the question, you know, do you think you're going to get rich off this thing? They'd say, no, I don't think we're going to get rich off of it, but we want to punish them for what they've done to us. That would be their mindset. And, you know, we want them to have to go through the grind and the anxiety of having this thing piled on to everything else that you have going on in your life. You know, so I think there's a real punitive aspect to it. And at the end of the day, I mean, it's an effective way to punish somebody, because the reality in this country is you can sue anybody. You know, you can walk into any courtroom, any courthouse, file a lawsuit against anybody for anything. Doesn't mean it's going to prevail. If it's super frivolous, it's going to get dismissed. And so in this particular situation where you have the real estate developer in the neighborhood, and they file the suit, and the suit becomes the punishment, and you only named like 3 or 4 of the homeowners in that initial suit, right? The rest of the community sees that and they're like, oh, yeah, I don't want to get sued. Like, I don't want to have to pay for lawyers. So they stay home. They don't go out and do the things that they're constitutionally allowed to do, like petition to keep this thing out of the neighborhood. They won't sign petitions. They won't attend board meetings. So what you've done effectively by filing the lawsuit is that you've chilled the exercise of the constitutional right to petition the government. And so that's kind of like how to define what anti-SLAPP is. And are you ready to kind of continue with the statute?
Yeah. Hold on a sec. Yep, sorry. All right, so all right, well, you know. So basically how they say, and it's like Bob said, I mean, it's a meritless civil suit filed to punish or silence parties from exercising their constitutional rights. That's kind of broadly how it is. And the petitioning rights include any written or oral statements made before or submitted to a legislative, executive, or judicial body or any other governmental proceeding, any and all oral statements made in connection with an issue under consideration or review by such bodies. So I think we're there for sure. Any statement reasonably likely to encourage consideration or review of an issue by such bodies. We need to figure out if like the police, law enforcement might fall into those bodies. I don't know, maybe the
I think a
executive.
judicial proceeding does.
Or what about executive? Well, the police themselves, I mean, to try and prompt them to arrest and investigate, you know, the House plaintiffs, I guess. Any statement reasonably likely to enlist public participation in an effort to effect such consideration. To me, I don't know how they're trying to get around this, and we'll see, like Bob will point out when we're going through the complaint, but trying to argue out of one side of their mouth that Aidan was just doing this for money, and at the other side that he gathered large crowds of people and enlisted all these people to come and harass them. There is no question, no doubt that he literally rose up the people to stand up for this petition, for this position that he was taking. So, but a very distinct feature, and I don't know if Bob already said this, here, unlike almost every other state, and what I was assuming was an issue before I sat down and read it, was it in Massachusetts, their Supreme Court has said the activity does not need to involve a matter of public concern. Although I think this here would have been a matter of public concern, but it's just like a very wide, a very broad statute, unlike a lot of other states. So
yeah, I mean, the whole point of it is like because this became law in 1994 in Massachusetts, and really the heart of it is that it allows defendants in cases where they've been sued, where it's going to have a chilling effect on those people's constitutional rights. It allows them to go in before the discovery starts, before maybe even an answer is put forth, to try to get this thing dismissed quickly before attorney's fees rack up. And really, the benefit to the defendant, if they win the anti-SLAPP motion, is that whatever fees they have been charged up until the point that they win that particular motion, and it will include the SLAPP motion, the plaintiff pays the defendant's lawyers. So, I mean, there's the bite. You know, you always want to have a bite in the statute, and the bite is that. So, you know, I mean, like, these are just the things that plaintiff's counsel obviously was aware of going into this. Like, you're not, as a plaintiff's attorney, you're not going into a case like this without thinking about the anti-SLAPP stuff immediately.
Yep.
And warning your clients, look, they're going to bring this, you know, this is what our, you know, analysis is on whether or not they're going to succeed on it. You know, they probably gave them a lot of information and allowed them to kind of say, you know, because you can make no guarantees in the law. You just can't. It's unethical to do it. You can't promise anything. You can't say, oh, we're 100% going to win that. You're not allowed to do it, you know? So they had to have been honest with them that there was a chance that we're going to lose this, and this thing's going to go away early, and you're going to have to pay for one or both of their fees, you know? And that's like, whether or not it's going to apply to Karen is interesting. You know, because it's a different set of circumstances. You know what I'm saying? So
I think she's got a constitutional right. Well, let me just circle back to the whole, they whether the plaintiff's lawyers thought about all of these things before they filed. You can be guaranteed that for each cause of action they have raised, they researched it. They researched the elements, what the case law has said constitutes sufficient pleadings, and clearly the anti-SLAPP statute as well. So there would have been a lot of research that went into this before it filed to make it hard as hard as the plaintiffs can, for the defense to get rid of on a motion to dismiss or the application of the anti-SLAPP.
Yeah. And then kind of like the case history, how it evolved after it became legislation. And that's, if you have a basic understanding how the law works, when you elect your local officials, whether it be state legislators, House, Senate, whatever. I mean, they're the ones who are making the law. They draft up these statutes. The legislation drafts up statutes. It's got to make it through the House and the Senate. And then if it's a state bill, the governor signs off on it, and then it becomes a law. And then what happens is nobody knows when that legislation is drafted how it's going to work in practice. Meaning, once people start using that particular new law, how does it work? Like, how does it operate? Are there going to be issues with it? And of course, as with any law, there's always issues. That's what lawyers do. You could pull up any statute, no matter whether it be criminal, civil, what have you, and you put two different lawyers, they will be able to interpret that statute in two different ways. That's just how it works. That's what lawyers do. They look at the same thing and they interpret it in separate ways, and then they argue, and they have a judge decide who's right. And so the first case was in 1998, and it was Duracraft Corporation versus Holmes Products Corporation. And this is the first time the SJC interpreted the statute. And then in 1998, the court said that in order for a defendant to win a special motion to dismiss, they have to show that the claims against them are based on their petitioning activities alone, with no substantial basis other than or in addition to those activities. So, meaning if the lawsuit is partly about petitioning and partly about something else, back in 1998, the motion would have failed. And that framework held for like 20 years. And then in 2017, a case called Blanchard v. Stewart, Kearney Hospital came up. And in Blanchard, what happened is the courts allowed for the plaintiffs to parse claims, and they gave them an alternate path. So showing that the suit was not brought primarily to chill the defendant's petitioning. So it changes, right? It goes from pretty much a hard line, and then the Blanchard court says, all right, lower courts, we're going to allow you to parse these claims out, and you're going to give the plaintiffs the opportunity to show that they have an alternative path, meaning that we didn't sue them just to chill whatever their constitutional right is. There was another reason that we did it.
Right. So the court is then supposed to look at the plaintiff's motivation.
Right. And that brings us to Bristol, right? So Bristol is a 2024 case, and there the SJC overruled Blanchard, and they eliminated the parsing. They eliminated the primarily to chill alternative path, and they restored the simplified Duracraft framework. Okay. And there's two steps now. So this is the current anti-SLAPP test. And the threshold is that the defendant must show the challenge claim has no substantial basis in conduct other than or in addition to the defendant's alleged petitioning activity. If the defendant fails at step one, the motion is denied. If they don't fail at step one and they move forward, step two is rebuttal. So if step one is met, the burden then shifts to the plaintiffs, the people that filed the lawsuit. And then the plaintiff must show A, that the defendant's petitioning activity was devoid of any reasonable factual support or arguable basis in the law, and B, that the petitioning caused actual injury. So if the plaintiff meets that burden, the motion is denied. If the plaintiff fails, the motion is granted, and the defendant gets mandatory attorney's fees and costs.
All right. So let's apply this to Kearney.
Okay.
Babe, what's the best argument for him?
It's going to be the Fustolo case. And the defense is going to argue that Aidan's speech was petitioning, okay? And that his reporting on the Read case was speech about matters that were pending before a judicial body, namely Karen's criminal trial. That his YouTube videos, that his blog posts, his social media were reasonably likely to enlist public participation and encourage consideration or review by the court, by prosecutors, by the board of bar overseers, by federal investigators. And that falls squarely within the constitutional right to petition. And so what do you think the plaintiffs will counter?
Well, so there's a case that so you just mentioned that Fustolo case, but that's based on the old, because it sounds like they just made this change in 2024. But I think what happened, I think I looked at that one. So if I'm correct, the journalist was like, so there was a difference between whether the journalist was seeking like to redress their own grievance or like they're just reporting. So the more objective you are, which obviously Aidan's the exact opposite, but the more objective you are, so I'm supposed to be saying what the plaintiffs will counter. Right. Sorry. I can't help but help the defense. I don't know what they're going to count. I mean, I know you have some idea, but me personally, I guess they're going to try to argue that this wasn't about public concern and he was just reporting, but I just don't think that they can make it. But I think, what do you think? Because
I mean, Fustolo basically was about a journalist who was writing articles, okay, and that they were written by the journalist, they were published in a journalistic venue about matters of public concern. And the court there found that, okay, well, you're actually a journalist and that's not petitioning.
But he's a journalist, but you cannot deny he was petitioning. He motivated an entire
that's what the court's
revolution.
That's what the court's going to be up against, like exactly that thing. And when we get to reading, and you can see the reason that I wanted to cover this stuff first is because it gives you context of how they fashioned this particular complaint with this exact argument in mind. Because when we get into a lot of the Aidan stuff, they're talking about how much he makes, that he's selling merch, all the shit that he was doing, which is trying to basically, that cuts against their argument because that puts him in the advocate side as opposed to the journalist side, where you'd think you'd want, if you're the plaintiffs, to keep him on the journalist side, because then they could say, well, you're not petitioning. Because I agree with you. I mean, the proof's in the pudding. I mean, when you have hundreds of people in pink shirts out there screaming and yelling every single day and cheering when Karen's acquitted, you see what the result of what he did is in real time. You know, I mean, there's no denying it. And there's no denying the fact that he's the one who drummed that up, you know. And one of the things that they're trying to sue them for is that was a conspiracy, you know, that was a conspiracy between Aidan and Karen, and that the heart of the conspiracy was to blame the people inside that house for what happened to John. And, you know, when we get into and we'll talk about that more because I have long thoughts on that in terms of where I land in terms of that being a conspiracy and who came up with that conspiracy or who developed it or where it came from. Because there's only one answer to that. And when you get to the point in time, if this thing survives the various attacks, procedural attacks that you can make on a complaint like this, and it gets to the point where the defense attorneys are answering, you're going to see what their response is going to be. And their response is going to be that this conspiracy that you keep calling it wasn't something that the defense made up. The defense was given a set of facts through the police reports that simply didn't make any sense.
Well, and also they had that one guy, the guy that came forward, that's who started all this.
I don't know if that guy is like a real person or not. It's like I find it hard to believe that no one has tracked that dude down or his kid. It was like, I can't even remember the guy's name. I'm sure people in chat.
And for people who don't know, and I'll probably say something wrong, I don't know if you know specifically, but if memory serves me, there was someone who came forward to David Yannetti and told him there was a fight in the house. This happened in the basement. The dog got involved. They beat the shit out of him. And that's what started all of this, right?
I mean, that's the story. That's the story. You know, that's the legend. Is that
but Bob and I have been talking.
I mean, because that story was like, dude was in the house, like, and he knew it for a fact. And then what I kept hearing about the story is that dad got involved because it was the kid, and that dad got involved, and he said, you know what, you're not saying shit about shit. Shut up. Like, forget you heard anything. Like, there's nothing to see here. These aren't the droids you're looking for. All that shit.
Can he avoid a deposition in a civil case?
But whatever the case may be with that guy, once they started looking very, very hard at this investigation and what didn't happen, it started to create questions. And you know, this concept, there's a reason that Alan Jackson and David Yannetti weren't sued. That's because they were being lawyers. That's exactly what defense attorneys do. We come up with alternate theories. It's literally our job description. We look at a set of facts. We look at what the state's theory is, and we say, wow, you know what? I think we've come up with an entirely different theory of what's happened here, and it's based on your police reports that you gave us. That's what it's based on. So whatever may have gotten David and Alan kind of down this path to start looking at the people in that house, the fact of the matter is that if there would have been a proper police investigation into the people in that house and they were cleared, we're not here today. It's that simple. It's like everyone wants to scream and yell at Aidan and the attorneys and Karen Read. The reality is you should be screaming at the Canton Police Department and the ATF and anybody else that was involved, because it was their failures to properly investigate what happened to John O'Keefe is the direct result of why we're here. And anybody can say, no one's ever convincing me of that otherwise. I mean, you could have asked for a consent search. The way that it looks on its face to the normal citizen is it was at a cop's house. And a normal person is going to say, you know what? And the reason that we're talking about this again, because that's where this case is going to live. If this thing makes it to trial, truth is an absolute defense to defamation. The truth is an absolute defense to defamation. And you know what that means? And again, it's the plaintiffs who have to prove the falsity, not the other way around. which is a big thing that you need to understand about this, because there's a lot of reasons why I scratch my head about that, why this complaint was filed. You know, when I kept seeing people talking about defamation things being filed, I'm like, okay, because the discovery in civil cases, whole different beast. Those depositions in this case, shoo,
Well, I'm just going to say this,
they're
and
going to be a thing.
it's probably not a popular opinion, but I think if these plaintiffs were involved in covering up and the murder and framing Karen Read directly, I don't know that they bring this lawsuit. That's just my personal opinion because of what you just said.
Right. Or they've covered shit up enough to where they feel comfortable doing it.
I mean,
like at this point,
that's true.
What else can they get from their phones?
I mean, I guess if
they might not have already.
Right. If they like wiped their iClouds and got brand new devices, then yeah, they're all clear. But if every single one of them has a brand new, no data that predates this, that's highly suspicious when you're coming to, like, you know, you're talking about preponderance of the evidence here. It's going to be like, that's going to lift some jurors' eyebrows.
Yeah. And again, preponderance of the evidence is 50.1%. It doesn't even have to be 51%. It could be 50.1, how they reach some kind of mathematical percentage in terms of being a juror. Well, we think we're at 49%. I don't, it's one of the mysteries of preponderance of the evidence, but it's basically more likely than not. Okay. That's basically what it is. And so, I mean, the one thing we know is the investigation and what happened is never going to change. That is what it is and will always be, you know? So like from their perspective, if they were somehow involved, then they're like, well, they've seen it all. You know, they still move forward on Karen. You know, because I mean, at the end of the day, I mean, if you're plaintiff, if I'm the plaintiff's attorney, I'm asking them, okay, let's assume that we prevail here. Okay. And preponderance of the evidence is the burden that has to be reached. Do you think that by winning this particular case that you're changing anybody's opinion on whether or not they think that you did something?
I mean,
if you can't, in that house,
if you can't change someone's opinion when it's, you know, a murder trial, how are you changing their opinion in the civil case?
That's exactly. You know, the people that think that Karen hit him are never going to not think that she hit John.
I mean, the people who think there is a flat earth still think that, despite Artemis just going up in the sky and circling the planet.
It's like a record, you know. I mean, it's just like a album, a vinyl, you know. I mean, it's like you're like everywhere you go, no matter what part of the earth or the moon you're behind, it still just looks like a flat record.
Oh.
You know what I mean? I mean, like, that's what their argument's going to be. All right, so back to the anti-slap.
So going back to the anti-slap, you also have.
Well, here I want to give you, like, I think how Aidan's attorney is going to. They obviously have to distinguish it, and I think.
Wait, you're talking about distinguish.
Remember, he can't just be a journalist.
I know, we just discussed this. We just distinguished Fusolo on his rising up of the people.
You're talking about they can't have it both ways, but they can.
Well,
he can be a journalist. He was posting his articles to his blog. He's got 500 plus articles or some shit like that. I mean, he was definitely acting as a journalist, but he was also acting as an advocate. He was doing both things. So I think that's going to really be the question is the fact that he was both things, both a journalist who was reporting on various things and also advocating. Does that hurt him?
No, it does not. I think he
Right.
was advocating through his journalism, and that was just sort of an aside to his primary purpose of advocating. But there's a second line of cases that deal with um, what speech that's primarily motivated by commercial gain as opposed to petitioning. And that then it would fall outside of their anti-slap statute. And I know when we were talking about this, you thought that that's why there's a whole slant in the complaint.
Yeah, for sure. I mean, when we get to it, like paragraph, it's like 70 in the 70s, it's talking about how much cash he generates on a monthly basis. And this is coming from shit that Aidan has said in various interviews, right? And they go into great detail pleading his monetization of his channel. And, he's got the merchandise, the subscriptions, donation funnels, the defense fund, all of it. And that's not by accident. That's not happenstance. That was his plan, and the plaintiffs are basically setting up a commercial motive argument in anticipation of the anti-slap motion, saying that this had jack shit to do with petitioning. This was this guy's business plan, and it had 5 acts. It had pre-trial and trial 1. It had the arrest, which is a tough argument for them because while Aidan's a pretty bright guy, he's going to see the potential for him to grow his channel with the facts that were presented to him in terms of reporting on this case. He's like, holy shit, this is crazy. I got to report on it. And then his activism ends up getting him arrested, because he's bullhorning and showing up at sporting events, all that shit, and ultimately does Aidan have the foresight to think that he's going to get arrested under Massachusetts' archaic witness intimidation statute? Probably not. But, he takes the hit, finds a good lawyer. Lawyer's like, oh man, this is like, you're now a champion for free speech. And it turns into that thing. And then Act 3 is obviously, Karen Read Part 2.
Yeah, and I think that the problem here is as you point out with this, that their anti-slap statute has like the two part process where on the to qualify for it to apply pre-trial, you've got to show like this is literally just covering petitioning activity and covers nothing else. I don't know if that means that it would just survive. Like, for example, if they thought every other claim except that bullshit, what is it, consumer fraud claim or whatever it is, was actually petitioning activity, that only that would stay, or I don't know. But then you could lose the anti-slap motion on the front because, well, there's some other shit there. This isn't all petitioning activity, and then still be entitled to its protections at trial. Like you could still win based on the same protections at trial, even if you don't win that first motion.
Yeah, I mean, look, I think in terms of kind of distinguishing Aidan from the Cadle case and that progeny of cases, it's like they're going to argue, look, commercial motive cannot be the standard here, or it proves too much. Because frankly, if you think about it, every journalist is monetized. I mean, it's a job. We get paid for working. Major newspapers are for-profit enterprises, right? YouTube creators who cover legal cases, such as us, were monetized. The defense is going to argue that those Cadle line of cases apply when speech is primarily commercial and only incidentally about public concern. And I don't think that that wins against Aidan because of what actually happened. You know, like his reporting and his insistence that they were trying to pin it on the girl for month after month after month. I mean, he started this movement to where, I mean, if that's not public concern, I don't know what is. I mean, there's still people. She's been acquitted, and there's still people, you know, that are very much completely invested in Karen Read and her civil cases. And I'm sure they're going to be equally invested now. And it's all born out of the first trial. And it's all born out of the reporting that Aidan was doing, you know? So I don't know. I mean, I could see the thing, you know, I can see maybe a partial anti-SLAPP result, you know, maybe as to some issues and some proceed, which I don't know if that's necessarily a win, you know. But one other thing that happens is that the case and the discovery process is halted. It's stayed while the anti-SLAPP gets litigated, you know. So that means deps aren't taking place, production requests aren't taking place. All the things that happen in civil cases stops because they're trying to keep the money, you know, the fees down while that thing's getting litigated. And while that gets litigated, and then it could get appealed, you know, if they lose that. So it's an interesting aspect of it. It really is.
Yeah.
You know? But I fully anticipate that it's going to get filed for sure. You know, I'd be stunned if it wasn't. You know, with Karen, I don't.
The problem is this mixture that they I was looking at that Bristol case, and the Supreme Judicial Court is saying they want it to be really hard to win on an anti-SLAPP petition because it's a complete shutdown of the plaintiff's petitioning activity, i.e. bringing the claim. So they want it to be like obvious that this is only petitioning activity. It's all petitioning activity. I don't know. I'd have to do a little bit more research, but it seems like it might be a little bit harder than I thought. When you read the way they describe it, sort of like in the head notes, it's like if it's to cover, you know, if it's petitioning activity or in addition to petitioning activity, and then you're like, oh, so it doesn't have to be all petitioning activity, but it's they're actually seem to be making it a little bit harder.
Yeah, it's not as clear a path for Karen to file an anti-SLAPP at all.
I mean, think so. She has a right to well, I don't know.
She was the defendant. You know,
the defendant has a right to speak up about their case.
Yeah.
I mean,
how are you arguing that that's petitioning? I mean, I guess you can make
the same way. Like the wrong person's been accused of a crime, go investigate. You know?
Yeah, I guess. You know, but like, how does that cut with the conspiracy thing? Like, if Karen
had the conspiracy, you're not. Reporters talk to litigants all the time. Like, I don't know why the two of them secretly talking turns into a conspiracy to do what? To do what they're allowed to do? The only way it's a conspiracy is if you buy their story that she knows she killed O'Keefe. Turtleboy knows she killed O'Keefe, and they are making this up to make money and to hurt us just because they're animals. It's
to get her acquitted.
Right, which I just think is that's the part of this that I think is the stupidest thing, that I'm shocked that intelligent lawyers Like,
well, I mean, we're going to get to the complaint. And you know, like, again, you guys are going to see why we went through the anti-slap stuff and why it'll make sense as to how they formulated this complaint. You'll see it. They avoid in the complaint any of the allegations made by the defense like the plague, obviously. And they focus on Karen got away with murder. Like, this is when we get to it, you know, I hit him, all that bullshit. Like, it all comes in, and the way that they put it out there is essentially they think the hardest thing to do is to prove a negative. And that's what these plaintiffs are tasked with doing, is proving a negative that we didn't have anything to do with John O'Keefe's death. Like, they're going to have to try to do that. Like, trying to prove a negative is damn near impossible. It just is. All right. So let's get into the venue fight. All right. So as we said, Higgins lives up in Barnstable. I don't know if I'm butchering that or not. And that's where they filed suit.
how far do we know how far that is?
I don't know. Somebody from Mass, tell us, how far is that from Canton? Like, probably, I have no idea, 30, 40 miles. It's not that far. You know what I mean? It's like Massachusetts is not a huge state. And it's hard to believe. I mean, if you got to pick your poison, and your two poisons are Barnstable or Canton, you know, you're gonna go Barnstable over Norfolk County. You just are, because that's some tainted ass swamp water. Like, a vast majority of people that live in Norfolk think that you know, the government's corrupt as shit. So that's not going to be the type of jury that you want to try to sit, because they're not going to be hearing you, or they're going to come in with their opinion already formed. And then you'll have to go through all that bullshit, you know, that concept of, oh, well, you know, the judges asked you those two magic questions. Can you follow the law? Or can you put that aside and can you follow the law? And then when that person says yes, say, all right, they're good to go. We're going to keep them on. You know, it's like that thing, which, you know, if you're a plaintiff's attorney in this case, you hate that. Like, you don't get to challenge that person for cause, right, for bias, you know? So, I mean, like, immediately you said that, in your estimation, that's going to be the next, after anti-slap, they're going to change venue.
No, I think they probably have to try to change venue before they do anything. I don't know. It's been a long time since I've, you know, had to consider civil law, but you might have to do that first before you file something substantive into the case. But
I don't know. Yeah, well, I mean, that kind of defeats the purpose of anti-slap, because you're trying to keep litigation costs to a minimum before you file it. You know what I mean?
Maybe there's some sort of loophole with that. Maybe there's something built into the statute that if there's a concern like I'm raising, that you have to make your motion to change venue before you start, you know, actively participating in the case. There's probably a carve out for anti-slap, because it has to be filed within 60 days. So,
exactly.
You know, but I'm not 100% sure, like, can form of nonconvenience work where it's like, well, everybody else lives here, because if you've got experts that are all out of state, that might not matter. I mean, it depends where all your, you know, witnesses are and how far it is. And, you know, I don't know. It's been a while before I had to think about all that.
I mean, I think if the defense does try to move it back, you know, the plaintiffs are going to have a pretty strong argument. I just think they will. You know,
if you can't get a fair,
yeah, you can't get a fair, you're not going to get a fair jury there.
They could say meet in the middle then. I don't know.
I don't know where the middle is, because did anybody answer in chat? How far is Barnstable County from Norfolk? Does anybody know offhand?
Here, I can Google it.
because I mean, ultimately, at the end of the day, I don't know what good splitting the baby in.
Says 45 to 90 minutes, depending on your route.
So that's with traffic. How many miles?
Wait, this says Cape Cod, driving from Barnstable County, Cape Cod. Sort of
Okay.
Cape Cod in Massachusetts is, wait, oh yeah, that's where Cape Cod is. Oh my gosh.
Been out to the Cape quite a few times, I see.
Yeah. So yeah, that's what it is.
So how many miles from Norfolk? Just put Norfolk County and Cape Cod. It's probably going to be like 45 miles, some shit like that.
I don't know. I'm on a computer, so it's like
God.
I can open up old school MapQuest.
MapQuest? Let's go to Google Maps. I mean, you can get that on your computer, Are you serious right now? You didn't think you could get Google Maps on your computer?
I guess so.
Wow.
Let me just say,
that's insane to me. Like, you didn't really just say that on a live, did you?
No.
Did you say you were going to use MapQuest?
It literally was in the search results. That's why I said it. So this says 60 miles.
Okay.
It depends because there's different parts of it. Like Canton, it says literally born Barnstable to Canton, 40 miles. Dedham from Sandwich, 45 miles. But then these other towns, 60 miles. Or let's move on.
Okay. All right.
I am starving.
This is going to be a long haul.
I know. That's why I'm getting a little worried.
I mean, you might have to go get a snack. I don't know what to tell you. This is long haul shit. All right. Let me pull this up.
Yeah. All that stay clean, keep it clean is dissipated.
All right. So for those of you who have never been with Ali and I during readings, she's a big fan of skipping shit. So, but let's read the intro for sure. Okay, so the case arises from a multi-year conspiracy orchestrated by Karen Read and Aidan Kearney to subvert and prejudice the criminal justice process in Norfolk County, Massachusetts. Through a coordinated scheme, Read and Kearney sought to protect and enrich themselves by defaming, harassing, and tormenting the plaintiffs who served as witnesses in connection with the Commonwealth of Massachusetts investigation into the death of John O'Keefe and its prosecution of Read for his murder. More specifically, Read and Kearney. Oh my God. See, here's the problem.
When you read it,
his name, when I read it, I'm always going to read it Kearney because for whatever reason, the Kearney family decided not to pronounce their name the way it's fucking spelled. So I'm always going to say it whenever I see it. I read.
I do the same thing.
I'm a phonetic reader. So Read and Kearney, what I should have gone through
is
done,
change the name.
Changed it. I have to go into the actual document, be able to edit it and change the name so it's Carney, which is how you'd pronounce Kearney. All right. So more specifically, Read and Kearney. I'm just going to call him Aidan because then I conspired to defame and did defame the plaintiffs by falsely asserting, among other things, that they were responsible for O'Keefe's death, conspired to conceal the roles in his death, and framed Read for murder. So the plaintiffs are now and have always been entirely innocent of any involvement in O'Keefe's tragic death. So Read and Aidan calculated operation to assassinate their calculated operation to assassinate the character and reputations of the plaintiffs has caused incalculable harm, subjecting them to a daily tidal wave of hatred, harassment, and intimidation. While the damage to these plaintiffs has been catastrophic, Read and Kearney's lies have also caused a rupture within the Canton, Massachusetts community, poisoning the community's cohesion and discourse. Read's and Kearney's lies, which were amplified by a vigorous public relations campaign, tainted the criminal prosecution of Read and deprive the O'Keefe family and the Commonwealth of justice, of the justice that they deserve. All right, you read this one.
I mean, are we going to talk about that though? Because that's just ridiculous and outrageous. They're doing it's like, first of all, the court system respects the jury system. So I don't think this position is going to be well received. Like, they're trying to act like this scheme that they did, caused the jury to somehow, wrongly find her not guilty.
The buffer zone. What about the buffer zone?
No, but the fact of the matter is, I don't care how much scheming you need to do to communicate with someone who's helping you get your word out. You have to look at everything like, okay, so what? If she really thinks you're framing her and that you are getting away with murder, I don't think I would stop at anything. I'll call everybody on whatever to free my man if he's accused of a murder he didn't commit.
Yeah. Thanks, babe.
How's that civil conspiracy? There needs to be an underlying crime at the end. And it only works. That's why I said, with this stupid thing, it only works if on the face of this complaint, it can, and that only gets them past what, like stage 1, that it can be seen as she's, have they pled a cause of action, taking the facts as true. So and
it's important to note that this is a complaint, a civil complaint. These are all allegations. That's all they are.
Right.
That's
so
all.
I don't know. I find that outrageous. So 3, the plaintiffs bring this civil action to finally hold Read and Kearney accountable for the wreckage that their conduct has caused, and to prove in a public forum governed by the rules of evidence. I think we did that once, lady or people, that Read and Kearney individually and collectively pursued a deliberate scheme to spread lies about the plaintiffs, used social media and other amplification means to achieve maximum penetration of those lives, and enriched themselves through their ill-gotten celebrity. And that's what Bob's talking about, why we went through the anti-slap. It's that kind of thing that you think, what the hell are they talking about? And now you know why. They're trying to put whatever they can in there so that they can survive that first attack. Because it's all about, in civil law, surviving the first attack and getting ready to survive the next attack. Because the more it costs someone to defend, the more likely they are to just say, all right, fine, I'll give you some money and go away. But I don't know that could ever happen here. I just thought people, what are they going to all go? Everyone's going to go broke doing this thing.
Not Aidan.
You mean because the public's going to help him?
Yeah, he'll crowdfund the fuck out of this thing. I mean, he's great at it.
Yeah, it's true.
He will crowdfund the fuck out of it. He will never settle it. Like, he'll fight it to the death. But like, we're going to get to that too, because I've seen a lot of talk. There's been all this in the drama, which I consider to be Act 4, the drama stage, which Ali and I hate. Ali and I don't cover any of it. I detest it. I think it's fucking stupid. And like at some point I started to think that was stage shit too. Like I don't know. Like I have no idea. But it became like a thing in and of itself, and it was basically, the Real Housewives of Massachusetts. Like that's what it feels like, all that bullshit. So we just weren't covering it at all, and then like this is a different thing though. You know what I mean? Like, this is a different thing. And I get it, because there's an audience for drama. People love the Real Housewives, and they're only watching that for instability and drama. That's why they love those shows. They want to see upheaval. They want to see other people struggling with shit. They want to see people ratting one another out. Like, people love that shit. So
All right, I'm gonna let you read the parties, which is something I would skip, but I don't know. The masses might not know this, so I think it's actually important. I got to get something to put in my mouth.
wow,
I'm sorry.
that was perverse almost.
Wow.
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 I didn't say it. You
Yeah,
said
you did just say it though. It's
no, I
ridiculous.
thought it.
And
You
then
said
said it.
I
No.
repeated it.
Wait, you turned it into what you said. All I said is I needed to eat, and then you turned it into a
No, what
thing.
you said is I need to put something in my mouth. Is what you
Right,
said.
and it could have been left right there.
Oh wow. I don't know. Could it really?
Mm.
All right.
Wow.
So let's get into the parties. Defendant Karen Read is a resident of North Dighton, Massachusetts. On January 29th of 2022, an intoxicated Read struck O'Keefe with the back of her Lexus SUV, incapacitating him and ultimately causing his death. On June 9th of 2022, Read was arrested after being indicted by a grand jury for second-degree murder, manslaughter while operating a vehicle while under the influence of alcohol and leaving the scene. Oh, big storm out here. The lightning. And leaving the scene of an accident resulting in the death resulting in death in connection with her causing the death of John O'Keefe. On July 1st of 2024, a jury failed to reach a unanimous verdict on the charged offenses, and the court declared a mistrial. In 2025, the Commonwealth retried Read, and on June 18th of 2025, the jury convicted Read of driving under the influence of alcohol, but concluded that the Commonwealth failed to prove Read's guilt beyond a reasonable doubt on the remaining charges. Defendant Aidan Kearney, aka Turtleboy, is a resident of Holden, Mass. Kearney owns and operates the website tbdailynews.com and is responsible for the content that appears on that website. Kearney also owns and controls the YouTube channel Turtleboy Live, the Rumble channel Turtleboy Daily News, the Facebook page TB Daily News, the X account under the handle Dr. Turtleboy, the Instagram page under the handle Turtleboy_news, and the TikTok account under the handle Turtleboy Daily News with underscores. So Kearney monetizes the content he publishes on those various platforms and outlets by selling merchandise and advertising, and by asking for donations on to his Cash App account at $ Uncle Turtleboy. In 2023, a grand jury indicted Kearney on witness intimidation charges related to his conduct towards the plaintiffs. The grand jury accused Kearney of harassing the plaintiffs, charging him with 8 counts of witness intimidation, 5 counts of picketing a witness, and 3 counts of conspiracy to intimidate a witness, which have been chopped down at this point. Plaintiff Jen McCabe is a resident of Canton, Mass. McCabe testified publicly and under oath at the trial and the retrial of Read. She also voluntarily testified as a witness before state and federal grand juries. Plaintiff Brian Albert is a resident of Norwood, Mass, and a retired sergeant of the Boston Police Department. Brian Albert testified publicly and under oath at the trial of Read. He testified voluntarily as a witness before the state and federal grand juries. Plaintiff Colin Albert is a resident of Canton, Mass. Colin testified publicly and under oath at the trial of Read. He also testified voluntarily as a witness before a federal grand jury. Plaintiff Brian Higgins is a resident of Sandwich. Am I mispronouncing that? I'm guessing Sandwich. Is that how they say it in Mass? Sandwich. I'm guessing like, how do you pronounce it? I know it's got to be some weird fucking thing. Is a resident of Sandwich, Mass, and a special agent with the Bureau of Alcohol, Tobacco, and Firearms and Explosives. Higgins testified publicly and under oath at the trial of Read. He also testified voluntarily as a witness for the state and federal grand juries. Non-party John O'Keefe was a resident of Canton, Mass, and a Boston police officer. Non-party Alan Jackson was Read's attorney. Non-party David Yannetti was Read's attorney. So here's the factual background. And this is where it gets interesting. Oh, it's just Sandwich? Thank God. Thank God. It's amazing. It's amazing. They actually pronounce something the way that it's spelled. It's amazing. So on January 29th of 2022, in the middle of a snowstorm, Read struck O'Keefe with the back of her Lexus SUV while she was driving drunk, leaving him to die in freezing temperatures on the front lawn of 34 Fairview Road in Canton, Mass. Read repeatedly told first responders on the scene, quote, "I hit him, I hit him, I hit him," end quote, and made other incriminating statements, including telling the police that she did not see O'Keefe enter 34 Fairview on January 29th of 2022. An investigation into O'Keefe's death resulted in an arrest, indictment, and prosecution of Read for his murder. Jackson and Yannetti represented Read in connection with the Commonwealth's prosecution. Shortly after her arrest, and consistent with her several admissions of liability, Read's counsel, Yannetti, told the court that O'Keefe's death was an accident by calling the charges, quote, "a tremendous reach," and explaining that Read had no criminal intent. That one's hilarious. That one is just hilarious. Like, I don't know if plaintiff's counsel's just playing dumb there or if they've never tried a criminal case, but I'm here to tell you that's par for the course. Yannetti didn't have any discovery yet. He had an indictment. That's it. That's the shit you say. He didn't know anything yet. So, like, them putting all that weight on that, and they always have in terms of the state, has just been so disingenuous. It really is. I mean, every lawyer says that. Every criminal defense lawyer says that shit about their client initially at the beginning of a case. They overcharge the case. In January of 2022, Kearney's occupation was that of aspiring internet personality with limited reach in the greater Boston area. He primarily commented on sports and other media reports. Kearney's objective was to attract attention to himself in order to build a brand and monetize his audience. Shame on you. How dare you, sir? You wanted to make money off YouTubing? It's outrageous. To do so, Kearney routinely engaged in provocation and courted controversy, while he described himself at times as a journalist. In fact, Kearney has no journalistic training, editorial standards, or oversight. Okay, so this is the launch. We're getting to the meat of their complaint here. The launch of the defamation campaign with a footnote. So despite her several admissions of liability, by the time she was indicted and arrested on murder and related charges in June of 2022, Read had set in motion a defamation campaign to falsely blame others for O'Keefe's death to escape responsibility for her own culpability. Prior to her arraignment, Read falsely denied responsibility for O'Keefe's death and, contrary to her prior admissions, falsely stated to law enforcement officers that she was not responsible for O'Keefe's death. I mean, a jury of 12 would disagree. I mean, I don't know. So instead, she falsely claimed that O'Keefe had been beaten up by Brian and Colin Albert. And that's footied too. So we'll get to those footnotes. Read knew the statement was false and that Brian Albert and Colin Albert had nothing to do with O'Keefe's death because she knew that she had hit O'Keefe with her car, causing his death. Read's false accusations against Brian Albert and Colin Albert was recorded on police body camera and released to the public during a pretrial hearing in April of 2024. To facilitate the spread and publication of her lies, Read found and enlisted Kearney. So, first footnote says the complaint does not include each and every example of Read and Kearney's defamatory statements and conduct. Upon the conclusion of discovery, the plaintiffs will identify all defamatory statements to be presented at trial. And then footnote 2, Karen Read during arrest, quote, "We're all in on the same joke, right?" Court TV, cited April 12th, 2024. All right, let's keep rolling. So as of April 2023, Kearney and Read, through an intermediary, and Read's counsel began communicating with one another to further Read's defamatory scheme against the plaintiffs. Kearney described the intermediary as a copy and paste vessel that just sent messages between Read and him. And that's got a footy. So Read used an intermediary and her counsel to correspond with Kearney to conceal the defendant's relationship and to create a bias upon which she could plausibly deny her role in Kearney's false claims. Pursuant to this scheme, Kearney would publicize and widely disseminate Read's false claims about the plaintiffs and others in an effort to destroy the reputations of these individuals so that Read could evade responsibility for causing the death of O'Keefe. As part of this scheme, Read sought to launder defamatory material by gratuitously including it in the pleadings filed with the court. Wow. So this is where they're going with it. I mean, because the motion to dismiss laid out their entire theory of defense, and it was third-party culprit. I mean, are these lawyers suggesting that a defendant doesn't have the right to put on a third-party culprit defense based on the evidence they've been presented by the state? Because when the other shoe drops on this, like I said, after all the pre-litigation, and when we get to the answer, because that's how these things work in a civil case, you have a complaint and then the defendants file answers. And it's an interesting concept of whether or not Karen and Aidan's attorneys will be working with one another. Because I mean, I do see some potential conflicts if it gets anywhere beyond the concept of the truth. You know, there are some potential conflicts there, but not as far as the truth defense. So, as part of the scheme, I read that part already. So, I think I left off with Read, through her counsel, also attached several non-public documents to the filing that had zero relevance to the narrow issue before the court. The purpose and part of those extraneous non-public documents was to convey them surreptitiously to Kearney, who would then amplify the public dissemination of the defamatory material, all in furtherance of the defendant's defamation scheme. For example, Read attached an unredacted copy of the Canton Police Department's incident report that listed the private addresses, cell phone numbers, and social security numbers of, inter alia, the plaintiffs. So Read made this filing in direct violation of Mass Supreme Justice Judicial Court Rule 1.24, and did so for the purpose of giving this information to Kearney so that he would further disseminate Read's false claims. I mean, what? If there's an intermediary, why isn't she just sending them, the intermediary, the address and the phone numbers? Why? I do not understand that. Like, what are they saying? Why would they do that? They're either communicating this shit or they're not. Like I don't understand why they think that was done intentionally to dox the witnesses when, I mean, because what they're saying is that it was disseminated surreptitiously to Aidan in order for him to broadcast it on his show by way of reading the pleading. Oh, well, I'm just reading the pleading. I can't help that it's on there. I guess that's what they're saying. All right, so after this filing, Read, through her intermediary, forwarded her April 12 filing And there was a footy there. I saw my girl Andrea in it. Footnote 3 related to Andrea Burkhart, Karen Read trial, journalism and revolution, a conversation with Dr. Turtleboy, Aidan Kearney, YouTube, January 29th of 2025. Okay. So after this filing, Read, through her intermediary, forwarded her April 12th filing to Kearney for the purpose of Kearney publishing and widely disseminating her false statements. With encouragement and like, am I wrong here? Were these sealed documents? I don't think so, right? I mean, these were public filings in a public trial. Wow. I mean, anybody, including Aidan, could have either gotten on the computer and or gone to the courthouse in the clerk's office and just gotten a copy of the filings, right? Am I wrong about that? I don't think I am. I don't know. With encouragement and direction from Read, Kearney published his first blog post days after receiving these false statements from Read. Indeed, prior to Kearney's April 18th, 2023 publication, Kearney shared his draft blog with Read through her intermediary, who provided Kearney with dozens of corrections, which Kearney understood to be from Read. After Kearney received and adopted these corrections, Read, through her intermediary, texted Kearney, "Amazeball sauce." What? Amazeball sauce? And thank you so much. What? Amazeball sauce? Is that a real thing? I mean, I've heard amazeballs. Has anybody actually ever said amazeball sauce? Is that an actual thing that people say? Like, where's the sauce thing come in? Is that real? I mean, I've definitely heard amazeballs, but I have to say, Karen Read strikes me as a relatively grown-up woman. That doesn't sound like something a grown-up woman would say, like Karen. I don't know. Maybe I'm crazy. Maybe she's a big amazeball sauce person. Maybe. I don't know. It's wild, man. It's wild. Amazeball sauce. Wow. That's some smoking gun allegations right there. I'll tell you that. You missed amazeball sauce.
I was listening to you just now when I got here.
You say that shit all the time. I don't even know why I'm playing. You're a big amazeball sauce person. You say it all the
I didn't even know anybody ever said that before. I don't understand why someone would say it. I don't know how it's a thing, or is it a thing, and I just don't know about it.
I mean, I've heard of the saying awesome sauce, and I've heard amazeballs.
Amazeballs. Yeah.
I've heard those two things. Maybe somebody combined them both and called it amazeball sauce. It's a different thing, I guess.
It's ridiculous.
It's pretty fabulous. Did you get a little bite there, kid?
No.
What? You're cleaning shit out of your teeth, bro.
I just had a handful of Cheerios.
All that time down there?
I was trying to order food. All the pizza. Apparently, we're in the midst of a tornado.
What?
Yeah, they're like, well, we're sheltering in because of the tornado.
What? This might be a shorter live than we expected. All right. So then on April 18th, 2023, the defendant's defamation campaign went public when Kearney published the first two parts of his Canton cover-up series, and that's got a footy. In part one, Kearney stated that, quote, Jennifer McCabe did not kill John O'Keefe since she's not physically capable of that. Brian Albert, Colin Albert, and the dog were more capable of that, and Colin Albert had the motive. McCabe was just the quarterback of the cover-up, end quote. He also explained that Jennifer McCabe, and this is quoted, would never have been able to cover up this murder without the assistance of law enforcement, end quote. Kearney admitted that he made these statements based on beliefs relayed to him by, quote, sources. I mean, am I insane, or wasn't all this shit in the motion to dismiss?
I mean, I think a lot of it was.
I mean, I'm pretty sure it was all in the motion to dismiss.
Well, did you get to the allegation where they
I'm still stuck on Amaze ball sauce, to be honest with you. That is something else. He also explained that, quote, Jennifer McCabe, like, could you imagine being an attorney and typing out the words Amaze ball sauce into a pleading and like thinking it meant something other than people were going to laugh when they read it? I don't know. All right. So where was I? He also explained that Jennifer McCabe would never have been, okay, without the help of law enforcement. Kearney admitted that he made these statements based on the beliefs relayed to him by his sources. Although not identified at the time, these sources were Read and her legal team. In part 2, Kearney posted, all right, let me get to the footies. So footy 4 was Mass Supreme Judicial Court Rule 1:24 prohibits the filing of personal identifying information in court documents without appropriate redactions, quote, to reduce the possibility of using such documents for identity theft, the unwarranted invasion of privacy, or other improper purposes.
That needs to be stricken. That whole allegation needs to be stricken. She has nothing to do and no control over the way her lawyer files something, and he is not a party to this lawsuit. Let's stop. This was the kind of allegation that I was like, did morons write this? Did absolute morons write that? Maybe they did some research and they have said that they have found something that says a party can be held liable for the filing under this type of statute for invasion of privacy if somebody files something. But I can't imagine in a million years that to be the case. It's ridiculous. And unless there's an allegation in there. Is there an allegation? Because my phone's dead. My charger's up there by you. So I wasn't able to listen while I was gone. But that her and David Yannetti were in cahoots as well. They were conspiring. I know he's not a party here, but does there seem to be an allegation to that extent?
I mean, kind of.
Did they outright allege that?
Well, they're going to get to it, I think. I think there's these text messages from David Yannetti where he's like, oh, that was awesome fucking live or some shit. Like, so
what?
I agree. I agree. So footy 5 is as of the date of filing. This series is now up to 545 parts. In footy 6, Aidan Kearney, Catton cover up part 1, corrupt state trooper helps Boston cop cover up murder of fellow officer, frame innocent girlfriend. TB Daily News gives the date. And then I
want to ask this before we go on.
It's worked. Why don't the hyperlinks work? I don't get it.
I want to just pose this before we move on.
Okay.
So you have a scenario where the cops are giving a press conference about this murder they just arrested or whatever. And the state's attorney sends them a text, great press coverage. And now there is an allegation that cop made the whole thing up, framed this person. How in the hell is it?
Because the state's allowed to do that. They're allowed to. They're like, hey man, you really did a great job making our guy look guilty in your interview of that particular person, or whatever. Your story was scathing. Good job. Made my job easier. I mean, you see it in every criminal case known to man. It's like what we're always bitching about. It's like that thing where in this case and in Richard Allen's case, I'm always talking about. It's like those were the two cases where you saw this rare thing where the defense puts their theory out to the public prior to trial, as opposed to it just being the state like it always is, which goes to your point. It's ridiculous. There's no prohibition from an attorney reaching out to any journalist ever.
Right. Unless he's sharing evidence that is not allowed to be shared with the public. If he's just encouraging him, oh, I like what you're saying, without providing information.
Get him, Tiger. Yeah. I mean, I'm sure that I'm pretty sure if the prosecutor in the Aaron Spencer case has seen any of our lives, he's probably upset with me. Yeah. Because like I have a very definitive position on that case.
All right, I don't know.
In part 2, Kearney posted screenshots of people's messages to him that were critical of his defamatory statements. 7. He made no effort to redact the names and proceeded to publicly mock them. Kearney claimed that, quote, most people are shocked and outraged about the mountain of evidence indicating that O'Keefe was killed by fellow Boston PD Sergeant Brian Albert, his nephew Colin Albert, and possibly others, end quote. 30, in reality, this blog post by Kearney, like numerous other defamatory statements that he made, was funneled by Read to her accomplice Kearney with knowledge that he would publish it.
But what have they said is wrong with that? What in the hell is wrong with that? Under what world is there something wrong with that?
I don't know. I mean, again, I'm going to go ahead and say I'm 99% certain that this is after the motion to dismiss was filed, which is a public pleading.
Yeah.
And the public has access to it. Anybody could have gone and gotten it. Shit, I wish I would have beaten Aidan to it. I would have ran with it too. 31 to Fox News. Yeah, you read for a bit.
To Fox News, Kearney later explained that after he published the beginning of his Canton cover-up series, his blog exploded. He had a record-setting audience with over 500,000 views. Is there a thingy there? A footnote?
Yes, there is.
It's just a link to the live. Everywhere Kearney explained that when he would first go live on his YouTube channel, he would usually have about 300 live viewers, but he had over 2,000 on the first night during his first live stream about the Canton cover-up. And that's another link. Also says see a future section. With his newly found audience, Kearney was now able to disseminate Read's false narrative to an even larger audience as Read intended. Indeed.
Also known as their theory of the case.
All right. I'm sorry because I missed the beginning. Did they, I just want to know, did they plead? I know they pled. Karen knows that she killed him, and Karen, set out to do this to get herself out of trouble. Did they also specifically allege Karen told Kearney she killed him and he was knowingly covering that up? Have they said those words anywhere?
Not yet. I mean, we're on paragraph 32.
Well, they've already have them like in cahoots. So I got a cough.
Is that the end of your reading, your brief?
No, I'm back.
Oh, maybe
I'm hoping I can do it faster than you, but
it's like vaping, man. It's like vaping.
So indeed, given the success,
storm, by the way.
What's that?
It's quite a storm up here.
Yeah. If the kids were home, we would never be able. They'd be having a fit. Read's false narrative. Oh, sorry. Indeed, given the success of the show at publishing and disseminating Read's false narrative to a wider audience, Read's intermediary told Kearney that Read Read's counsel, Jackson and Yannetti, wanted to speak directly with Kearney. Conversation between Kearney and Read's counsel occurred on April 20th, 2023, in which they spoke about Read's campaign. Kearney secretly recorded that conversation. 2 days after speaking with Read directly to Read, that him secretly recording one of his cohorts' conversations plays against any civil conspiracy because it does in fact show they were at odds. So there's that. 2 days after,
I was thinking the same thing.
2 days after speaking directly to Karen Read's counsel on April 22nd, 2023, Kearney made additional false statements at the direction of Read. Now are they making stuff up? They're just saying it. Okay.
Did you skip the footnotes?
Did I? Because some of them I can't see. No, I didn't skip any yet.
Oh, all right. Wait, are you on page 9?
Yeah.
Oh, yeah. So you skipped the footnotes. That's all right.
No, I said one was a link to Turtleboy Live and one says Supra C.
Oh, yeah.
Okay.
Oh, yeah.
In episode 575 of his weekend live show, Kearney repeated Read's false claim that O'Keefe was killed inside 34 Fairview during a fight with Colin Albert and or Brian Albert. During that show, Kearney also used the phone numbers that Read and her counsel intentionally made public. So yeah, Read and her counsel intentionally made public in their April 12th, 2023 Rule 17 motion. Kearney used those numbers to call McCabe and Brian Albert and directly accuse them both of a cover-up. Kearney's voicemail left on Brian Albert's phone asked, "Did you kill John O'Keefe or was it your nephew Colin? And are you covering up for him? How did your dog get downstairs and begin biting Mr. O'Keefe?" Later, in the April 22nd, 2023 show, Kearney shared images of the Canton Police Department's incident report, distributing to his thousands of followers the private addresses, phone numbers, and social security numbers of the plaintiffs. As a direct result of Kearney's publicizing their personal identifying information, which he received from Read, which he received from a public filing. This is the kind of shit, like these lawyers, I really hope they get bitch slapped at least on some of this. I mean, I'm not through it enough to say all of it, but this is bullshit. This is complete bullshit. If there's not an allegation that Yannetti intentionally filed that at Karen's direction, and you haven't told me that they said those exact words as of yet, that we've read as of yet. So this is crazy.
Wait, there was some shit up there about some crazy, like you commented on it, like where you remember you said like in what world
that was him filing it,
right? Or they drafted it, you know, because they were implying that Karen somehow convinced Yannetti and Jackson that her conspiracy theory is what happened.
Right,
but
if
they're trying to put it all on Karen as if she cooked it all up, as opposed to all the things that we know about the weird shit that happened in that house and the lack of investigation that happened at that house.
Right. Well, no, but I just mean in order for them to say all of this was part of Aidan and Karen's plan, the filing of their numbers published publicly, they have to allege that David Yannetti or his office or his staff intentionally, at the direction of Karen, for the purposes of those numbers being able to be made public so that Aidan could then turn around and use them. You know what I mean?
Yeah, I know what you mean.
As a direct result of Kearney publicizing their personal information and identifying information, which he received from Read, the plaintiffs, who were not generally recognized or responsible for O'Keefe's death, began to experience disturbing levels of defamation, harassment, and abuse by members of Kearney's audience. Oh, I'm so sorry you guys lost your order of protection case. I'm so sorry. This is one big order of protection case. Like, what is this? I can't even believe they. Honest to God, they must have paid these lawyers a shit ton of money. Is all I can think. I mean, this is a lot of work. This is exactly what Read intended when she began to use Kearney to disseminate and publish her false story. Oh, so now Karen was going to know that somehow the staff of David Yannetti was going to file an unredacted identifying paperwork. I mean, I'm just going to say Yannetti does not seem like the one who's going to participate in some shit like that.
Or that David Yannetti is going to allow his client, and I don't care who it is, to dictate how he is going to strategize the case. Not a chance.
No, but especially not, I need you to accidentally file this document, against the rules and with the, information. Whatever. Okay. Sorry, guys. Indeed. Minutes after Kearney's April 22nd, 2023 broadcast ended, Yannetti, who was watching the live broadcast, messaged Kearney congratulating him. That was priceless, dude. Great fucking show. Really enjoyed the turtle reporting. So fucking what? So fucking what? I'm sure he did.
All right.
And
do we have people on the opposite side in chat?
Oh, I'm sorry, because I'm probably getting
No. I hope so. What does that matter? Somebody give me the DB. You're in here. Give me the argument why the fuck that matters. How is that some kind of damning evidence? Are people under the misconception that attorneys are not allowed to text anybody ever?
Attorneys are always happy when there is, let's say, a reporter or anyone putting out that their client is innocent. Would it be a thing if the lawyer, as opposed to the client, saying, "Hey, I'm innocent, tell the world"?
I mean, we had one guy, one out of all the reporters in Omaha. There was Jake. Jake was the only one guy, and he was just giving him a fair shake. And we invited him out to Chicago to interview us. And we were like, thanks, man. Like, for not being like a torch and pitchfork guy. Like, thank you for just trying to make sure that our guy gets a fair trial. We appreciate that. Thank you. Yes. Come to our office.
Conspiracy.
Let you into the weird. Yeah. Right.
Conspiracy.
So it's a huge conspiracy, which worked really, really well in that case.
Yeah. Yet Read and her counsel repeatedly deceived the public about Read's coordination and relationship with Kearney, in part because they knew that using Kearney as a defamation mouthpiece could subject Read to civil liability for defamation and related civil misconduct. Wow. For example, during a September 23rd Boston Magazine interview, Read and her counsel stated that they had never been in contact with Kearney. This statement was false and intended to hide the fact that Kearney was carrying out Read's defamation scheme. So that's footnote 10, and it's just a link to the Gretchen Voss. Oh, this one is live link. These are live links.
For you. They're not live for me.
Oh, I don't know. I opened mine up in Acrobat. I don't know where you're watching.
I'm on Acrobat. I don't know.
10, 11, and 12. The mouse doesn't come up when you turn it into a finger hand.
No.
Huh. Mine does.
It's usually blue.
No, but I always take I never have mine blue in pleadings where they link to something.
Yeah, no.
Actually, sometimes I do so that the court knows.
Oh yeah, actually it does work. It does turn into a hand. Mine's not blue either.
All right. No. Okay, moving on. So, I mean, a false statement to hide, carrying out Read's defamation scheme is a ridiculous stretch. Even if there's evidence that it was a lie, that he sent that message to.
Who gives a shit? Like I would have assumed, because they were making implications, like when that particular interview took place, the state was already alleging that they were in cahoots somehow. Like that was a thing with them. And David Yannetti saying, hey, dude, great fucking show. Like that's not the substantive kind of thing that I would consider to be communication as to what they were implying. Do you know what I'm saying? They were implying something nefarious, like what this complaint is implying.
Right.
That was the kind of communications, not like, hey,
Right.
good job, bro.
Right.
You know,
No,
like that's not a substantive communication to me.
I 100% agree. And we can address it in this next one because I just read it. Moreover, 20 months after telling Kearney that his April 22nd, 2023 show accusing McCabe, Brian Albert, and Colin Albert of being involved in the death of O'Keefe was a great fucking show, Yannetti disavowed Read's relationship with Kearney. How are those two things related? Him, the lawyer, commenting on a great show, and Read and Kearney having a relationship, those do not track. Those sentences do not track. In an address he gave at Boston College Law School on November 11th, 2024, regarding Read's first trial, Yannetti said he had concerns about Kearney and that he was someone you want to keep at arm's length. Yannetti also said, notwithstanding his undisclosed direct and indirect communications and coordinations with Kearney, that Kearney's tactics, quote, are not the tactics of a refined defense attorney. So here's the thing. I don't know, are we getting to a bunch more communications or did we just hear the crux of it? And you can't tell. There's not 1 ounce of me who does not think that Yannetti came to think that Kearney was somebody he needed to keep at arm's length and that his tactics were not the tactics of a refined defense attorney. And that doesn't mean that he didn't think that first show was a great fucking
great
show.
That was a fucking great show. However, he is a bit of a loose cannon, so I'm gonna it's probably better if I kind of keep him at arm's length. You know what I mean?
And then it depends how you define arm's length. You know, you're not going out to dinner, okay?
Right.
Maybe you are at some point. I'm sure
they Sox game together.
I'm sure they did at some
point.
point.
The Pats.
Similarly,
it's like that other one that you say.
Similarly.
There's another one that you just
Jackson publicly denied.
Particularly.
No, particularly.
Oh yeah.
No, don't be ridiculous.
Oh yeah. I've
always
looked at words in here so that you can prove me right.
Yeah. Jackson publicly denied communicating and coordinating with Kearney, 2 different things. So he can deny communicating and coordinating with Kearney based on, because there's an and there. So that would be a truthful statement based on what they have told us so far, that he didn't communicate and coordinate. He spoke words at, but he didn't communicate and coordinate. Doesn't say and or. In an October 18th, 2024 interview, Jackson denied involving Kearney in Read's public strategy. Yet, during that same interview, Read acknowledged that she had communicated with Kearney frequently, but she limited that disclosure, claiming that the two only spoke in the months leading up to the March 2024 criminal trial. Footnote to an Abby Parks Dateline special. On April 20th. What?
The footy said the Dateline special, from a coy tipster to calls with Turtleboy.
Wow. On April 24th, 2023, Kearney published 10 of his Canton cover-up series, wherein he again accused McCabe of covering up the murder and pretending to be a compassionate person while a completely innocent woman faced decades in prison. And that one's the series was called Jennifer McCabe hired boomer mobster attorney Kevin Reddington, who claims she passed a polygraph test. All right. Here's the thing. I do not doubt that Aidan is 100% convinced that these people covered up the murder. I don't know where I fall on it, but if I was 100% 100% convinced, or for someone 100% convinced, that seems perfectly fine. Y'all got the wrong killer. Here's the right killer, and I'm going to keep screaming it from the rooftops until you do something about it. I just don't see the conspiracy. Oh, it continues, though, in Section B. So in response, Read, through her intermediary, messaged Kearney stating, please tell Kearney that article might be his best so far. Kearney responded, really? Thanks. Thank her. Thank that. Oh, really? That from her? I don't know. Really? That from her?
Wait, where are you? You lost me.
41.
Oh, okay.
So Aidan was like, wow, Karen said that, which makes me think that he wasn't used to her really commenting and saying stuff like that if he's like surprised. This intermediary replied, yup. Oh, okay. Also, I see nothing wrong with this so far.
Plus it flies in the face of the whole conspiracy thing. Like, that's like a guy who's like, really? She read my shit? Like, where's it contradicts the concept of a conspiracy where two people are making this
plan together.
Plan.
Right.
Constantly communicating.
I'm reading this and then I'm going to go grab that pizza I just cooked. I don't know if you want some slices. Wow. Since April 2023, Kearney had published 545 parts of his Canton cover-up series, along with countless other pieces of content, including posts on X and YouTube, falsely claiming that the plaintiffs were responsible for O'Keefe's death. Kearney's content has spanned thousands of tweets, hundreds of blogs, hundreds of YouTube videos, and countless other public statements across a variety of platforms. Kearney has also continued to spread his harmful, defamatory statements in interviews with multiple public sources. Thanks for proving petitioning activity. Thank you for proving petitioning activity. That's how I see it. This one's called A Complete Listing of Every Turtleboy Interview Before and After Karen Read Not Guilty Verdict. And there it is. I shall return.
Wow. All right. So B, the conspiracy continues. So Read and Kearney continued communicating before, during, and after her trials to coordinate their defamation of the plaintiffs. Read and Kearney agreed to act in concert and use their defamation of the plaintiffs to subvert the Commonwealth's prosecution, to attract an audience and to monetize that audience and their celebrity. In furtherance of this scheme, Read regularly funneled non-public information to Kearney using tradecraft, such as intermediaries, so that Kearney could selectively publish. And then we've got a couple of footies here. These are TB News ones. At Read's behest, certain non-public material for the purpose of casting false suspicion on the plaintiffs and away from Read. Read instructed Kearney to falsely claim that he had not received information from Read, when in fact he had done exactly that. For example, on April 23rd of 2023, despite having already publicly accused Colin Albert of O'Keefe's murder at Read's directions and encouragement, Kearney inquired of Read's intermediary regarding how Read knew that Colin Albert was ever at 34 Fairview on January 29th of 2022, after O'Keefe allegedly arrived. In response, Read, through the intermediary, responded, quote, Brian and Nicole and Chris and Julie all testified he was there, but I can't send the grand jury testimony because it's sealed. That statement was not true, as no witness ever testified that Colin Albert was at 34 Fairview on January 29th after Read's vehicle arrived at that location. That same day, Read also informed Kearney through the intermediary about the details of an alleged non-public ongoing separate investigation excuse me, apparently related to law enforcement investigation of O'Keefe's death. In a message to Kearney, Read, through the intermediary, stated, "Not public. The feds have been involved longer than anyone is likely guessing." You better step off, dude. This guy's over here sniffing this food. What a guy. All right. So 47, moreover. All right. So who's the intermediary? I'm sure you guys know, right? Like, I was not paying attention on the Twitter machine like that. And I certainly wasn't reading Aidan's articles. Who's the intermediary? And where, whose phone are they getting these off of? Are they getting this off of the intermediary's phone, or are they seeing the messages from Karen to the intermediary? Natalie the German. All right. So where are they pulling this information from? Do you guys know? Since they're not citing it. Do you guys know where? So these are from the signals, from all the signal communications. They have Aidan's phone extraction. The fool gave to Meredith. Okay, so they turn that over. But is that an intermediary communicating with Aidan? Or is that, like, how are they proving that Karen texted that to the intermediary? Anybody? So Natalie's phone. Okay, and are you guys seeing the communications from Karen to Natalie? So Anna's saying yes. All right, I'm looking through. I'm seeing what y'all are saying. They interviewed her. Okay, what I'm asking is a simple question. Do they have proof from an extraction from either Karen or Natalie's phone that shows that Karen lied about that grand jury? Because that's the first thing of significance that I've read, and we're 47 paragraphs in. Aidan's mentioned. That's not what they're saying, though. They're not saying this. They're saying that they saw it from the intermediary. Okay. What I'm asking, it's a very simple thing that I'm asking, and you guys are all saying the wrong things in chat. Do they have proof, an extraction from Natalie's phone that shows Karen Read texted the words, Colin Albert was at the house, multiple people at this grand jury testified to it? If we don't know, we don't know. I don't know. I mean, all I'm saying is that's the only thing that I've seen thus far in this entire thing, if true, because these are just allegations. But unless it's a message directly from Karen, that doesn't matter, dude.
Oh, I see it now. This paragraph 45. Well, yeah, they obviously have that on Aidan's phone too. Haven't all his messages been released?
What I'm asking is, they keep saying it's an intermediary who's telling Aidan this shit, not Karen.
Oh, you want from Karen to Meredith?
To Natalie.
Is that what you're saying? To Natalie. Sorry.
Karen to Natalie, because that's the only way it proves that Karen actually did that she lied about the grand jury testimony.
Yeah, this gets them nowhere unless they have the bootstrap evidence that
I mean, I
either
don't give a shit. Like this Natalie chick could be saying anything. Oh
right.
yeah, Karen told me that the moon is made of cheese. Oh no shit.
Yeah.
I
Yeah.
mean,
It's like Catfish 101. You kidding me? Started off as Karen, but then,
I guess
Natalie liked to chime in every now and then.
I guess we'll have to wait and see. So I understand that, but we still don't know. I'm assuming if they're putting in it a pleading that they're going to be able to prove up that Karen actually texted those words to Natalie.
I mean, there's a text, there's a quote. Oh, you mean, sorry, that Karen texted them to Natalie.
Right.
Well,
All
I
right,
think
you pick it up
they
on
had that. I think they would be saying it right here.
right.
Well,
Why wouldn't the pleading say the extraction from the signal
no, I agree. Right. I think they would be saying it if they had
showed
it.
that Karen Read texted these words in signal to Natalie.
Who then
Natalie,
in turn,
the intermediary, then texted
right.
them.
If they had that, it'd be in here.
That's what I'm saying.
No, they don't got shit. This is fairy tale story time, dude. This is fairy tale story time. Where'd you end? Because I'm telling you, I was afraid to walk away. I'm riveted by this. I wish I had a big giant bowl of popcorn. Actually, we do have popcorn.
Wow. All right,
but it's like
I'm gonna eat. You read.
You go. But like Bob was saying, he and I haven't stayed up. I've got no idea other than knowing that Aidan's messages, got publicized. I've got no idea what the hell people learned from this. So I don't know if this is some of it or what, but this fictional story that fiction mixed with nonfiction, but they're putting their own interpretation on it. It's got me. It's got me. All right, I missed what Bob said, so I can't see y'all, but I'm going to start with 46. The same day, Read also informed Kearney through the intermediary about the details of an alleged non-public, ongoing, separate investigation apparently related to law enforcement's investigation of O'Keefe's death. Well, that was happening, so I don't get it. In a message to Kearney, Read, through the intermediary, stated, "Not public. The feds have been involved longer than anyone is likely guessing." Are you to tell me that people on trial aren't allowed to talk to their friends and their family? Like, we've got no idea whether this woman shared this information or Karen told her to share this information. But like we were saying a moment ago, if that was evidence they already had, it would be spelled out exactly like Bob, mentioned. All right. Moreover, on December 1st, 2023, Kearney posted a YouTube video in which he included audio that had been recovered from O'Keefe's phone investigators. And that's on the live called Karen Read case, Jen McCabe 911 tape breakdown. How is that a 911 call? How is that off of John O'Keefe's phone? All right, I'm moving on. Wearing a Jackson Yannetti 2024 t-shirt that is for sale on his website, Kearney played audio from a voicemail that Read was leaving for O'Keefe at the time she found O'Keefe's body. See, this is assuming facts that don't exist. What kind of bullshit is this? So I'm sorry, plaintiff's counsel, but it seems you're doing the exact same thing that you're accusing Karen of doing. Y'all are over there conspiring to make it seem like Karen, innocent Karen, who had nothing to do with the finding of, what happened to to John and not knowing it until the morning after, doing this shit. This sounds like this whole lawsuit is a giant conspiracy. I bet you guys all talked about it. Maybe there were even some messages about it. Is that you all scheming to make this fake story to cover up and feign outrage that you're being accused of a crime you actually committed? I mean, we can do this all day. We can do this all day. All right. Where was I? Oh yeah. Kearney played an audio from a voicemail that Read was leaving for O'Keefe at the time she found O'Keefe's body. Oh, wait, that's actually real? Is that when she actually did find the body? Guys, I'm sorry. I thought they were acting like she saw the body earlier and then was making fake phone calls. They're actually talking about when she actually did find the body the next morning. Oh, Lord. Yeah. Okay. So sorry, guys. I misread that to be like they were talking about like on her drive home when she was leaving him the voicemails because this said, yeah, okay. All right, my bad. But, everything I said, it still applies. Eventually, Read, and just to explain for anyone out there who hasn't tracked my whole thinking process, I was thinking that this whole, they've got this recording from when she found the body, that they were talking about the prosecution's theory that Karen had actually seen and was fully aware of the body. She knew where it laid before, and then on her drive home, called and left John all these messages faking. I didn't realize they were actually talking about the message when they found him in the morning. Okay. Eventually, Read and Kearney started communicating directly for the purposes of sharing information, coordinating the timing of defamatory publications, and aligning Read's litigation strategy with their shared public defamation campaign. See, these are all the key words to get them in a conspiracy. But again, if it's shared, why in the hell is she surprised when he does something well? When she thinks the information he just conveyed was the best he's conveyed thus far. To do so, Read utilized Signal, an encrypted messaging system that avoids detection and aids deletion of communications. What is with these people just thinking communicating on Signal means that you're conspiring and that somehow you get to just imply because you used an app, you're up to no good? I mean, were they wrong? Because apparently people were, extracting phones and sharing calls and recording calls and stuff anyway. So, you know, um, Read and Kearney ultimately exchanged over 189 phone calls, totaling more than 40 hours in 2023 alone. That's nothing. Not including those countless messages exchanged through Signal. In conspiracy with Kearney to defame the plaintiffs. There's the other thing. Okay? Let's say they establish a conspiracy to share information that was otherwise not supposed to be available to the public. That is still not for the purposes of defaming the plaintiffs. And that is not something they're going to be able to plead away the the very blatant other reason to be doing this. This is you guys, I don't know what other lawyers are saying, but this is stupid. The fact that these lawyers spent all this time putting this piece of shit together is crazy. But a lot of times with civil suits, it's like, all right, I got to put all this out here and I got to survive that very first hurdle and then I'll take whatever they're offering. But again, I don't think that's ever happening here. So Or maybe they just figured I got to file something. These people really want to pay me to file something. They're adamant they want something of public record that has their side of the story. You know, I don't know. I can't imagine that there are lawyers somewhere in their offices that thought this is a claim that makes sense. I'll allege it this way. Because you know, anybody can look at this objectively and say, well, we got a big problem here because it's going to be impossible for us to prove they were motivated at defaming you instead of exploring a possible alternate scenario. I mean, did they learn nothing? Did they learn nothing from the pound cake?
It's Streisand effect. It's going to be big time here.
I mean, I think that this case couldn't get any bigger.
I mean, the thing about this case with the defamation thing that's going to be the biggest problem for the plaintiffs is them proving falsity. Like, how are they going to do it? I mean, because they're literally going to go in there at trial and put on their entire Karen Read season 1 defense. That's what the entire defense is going to be. All the shit they put on, they're not going to have any of the barriers that Kearney was putting up. They're not going to have to try to get it in through Bowden. They're just going to sit there and say, yeah, Brian Higgins drove to a fucking military base and cracked his phone and threw it into a dumpster. You know, Chloe disappeared. They sold the fucking house. They redid the floor. You know, there's these things on his arm that look exactly like animal. It's like,
it's fucking, people have eyes. We all used our independent eyes. And those are animal scratches, bites, whatever. But they're not random slashes of glass that happen to just, shatter everywhere. It's just so, I can't get over it. And we're only 13 pages in. And you told me we'd be reading this for an hour. Do the people still want us doing? Are they interested? Are they finding this entertaining?
You talk a lot. I talk a lot. You know, we make commentary as we're reading through it. If we were just plowing through, probably be an hour and a half.
Probably. I can't. I just can't. I really can't with this.
2.5 hours in.
Yeah. And I think that pizza place just wanted to. I don't think there's any.
You burnt the shit out of that pizza, by the way. I mean, what I told you can't leave it on that middle shelf. It's got to be at the bottom, yo.
I'm still hungry.
All right, come on.
All right, okay. Read knew that Kearney's and her statements blaming plaintiffs for the murder of O'Keefe were false because in reality, she was responsible for O'Keefe's death. You just killed your fucking conspiracy. You cannot have a conspiracy where one person knows of it and the other person is being tricked into thinking it's real. You already said that you sent this man a message that said these people testified at a secret grand jury that this guy was in the house. Where the fuck is your conspiracy? You deceived somebody to believe I'm saying if we even bought what they,
But and that's where a conflict between Aidan and Karen would exist.
Right.
If that's true, if they can prove that up, Aidan's going to be like, well, she fucking told it to me. Like I had no reason to believe it wasn't true.
You can't have a conspiracy where only one person knows it's false. Only one person knows it's a lie. That's not a conspiracy. No, that's not. I think these people should be really bitch slapped. I hope to God they are. In furtherance of the scheme, on May 3rd, 2023, Kearney met with Read, Jackson, and Inetti for the purposes of coordinating Kearney's extrajudicial defamatory publications with Read's litigation and media strategy. You please back this the fuck up. That same day, and after meeting with Read and her counsel, Kearney posted a YouTube video reacting to Jackson's press conference after a court appearance. And that's one just called press conference, blah, blah, blah. During the video, Kearney stated, John O'Keefe was murdered by Brian Albert and Colin Albert, and the frickin' dog and every other single person in that house who remains quiet to this day and participated in the lie, they're all guilty of murder as far as I'm concerned. They're participating in it. What the hell? Oh, here's the next sentence. Okay. By accusing every other single person in that house, Kearney intended to include McCabe and Higgins in his defamatory statement, a fact that his followers would have understood in light of prior publications. He's not saying anything different than he has said before. Where is this coordination? What did he get out of this meeting? Where's the, no.
I mean, here's the bottom line. And, I'm not in Aidan's brain, but Aidan read the fucking Rule 17 motion to dismiss, and he believed it.
That's right.
He absolutely believed that it was exactly what happened.
Right.
And it's again, I always bring up, which probably annoys Karen Read folks, the Richard Allen shit, but it was the same thing. There were people that found the Odinist thing to be completely legitimate, that the sticks were placed there, that they were forming runes, that these types of people that dabbled in
investigating them, they confessed to the crime.
Right, it was all the shit. It was all the shit.
For God's sakes, I wish that somebody, maybe we should convince Rick's wife to file a lawsuit against these guys, the third-party suspects, and the prosecutors and the cops.
Right.
For malicious prosecution, civil conspiracy, defamation. Well,
all those things.
Defamation might be hard considering he's proved guilty beyond a reasonable doubt.
Well, that would come after he's freed.
I know, but I'm just saying right now and say y'all made this up. He confessed and, this was all a scheme. You guys destroyed your phones. Whatever, I'll move on. On May 24th, 2023, in conjunction with publishing part 39 of his Canton cover-up series, Kearney published a YouTube video reacting to Jackson's press conference following another court appearance. Footnote, in the video, Kearney stated, Jennifer McCabe and Brian Albert were involved. They're covering it up. Yeah, we know. We get that. He's been saying that. In a subsequent blog post, and it's just like he's acting like it coordinates with what the defense team is doing, but he did that every day, didn't he? He had a schedule. Why don't you tell me the times he went off the schedule that somehow coordinated with the press conference? And why would someone who covers this case, the first thing you're going to do if you're covering a case is get on your live as soon as one of their lawyers have a press conference? That this is the stupidest conspiracy plan outline I've ever seen.
All I could tell you is that if Aidan didn't exist in the world and I ran into that Rule 17 motion and read through it, and I'm like, man, this shit's like crazy, that I would have formed my own opinion that there was a likelihood that the people in that house may have had something to do with this guy's death.
Right.
Without Aidan's help, I would have come to that own conclusion myself from a pleading that was filed in the case by Karen's defense attorneys that came from the evidence provided to them by the Commonwealth. That's where I'm at with it.
Yeah.
It's this thing, man, something.
In a subsequent blog post, he continued, the McCabes have the look of evil in them when you see them in person. These people with no shame aren't the least bit deterred by the fact that millions of people know they participated in a murder and subsequent cover-up of a murder of a Boston police officer. Days later, on May 30th, 2023, Kearney published part 43 of his Canton cover-up series, wherein he discussed McCabe yet again, shocker, referred to her as Horseface, I mean, sorry, but you got a bit of a horse face. And reposting a video that Kearney previously took confronting McCabe and calling her a killer cop. Notably, a cop killer. Sorry.
Very different things.
Yes, very different things. 19, it's just another link. Notably, the blog post covered the denial of an ex parte harassment prevention order that McCabe sought against Kearney in Stoughton District Court based on his repeated public harassment of her. Now the judge is going to be like, oh, I see what happened. She couldn't get it that way. She's coming at it this way. However, McCabe's HPO request was not public information. Instead, Kearney received this information directly from Read's counsel, Yannetti, who sent a text to Kearney that McCabe's request for HPO had been made and denied. In particular, Yannetti wrote to Kearney, HPO denied.
And?
Yeah. Conspiracy? To do what? Conspiracy to tell him y'all tried to get protective order or whatever they call it there.
Wait, I mean, wouldn't that show up on a docket? I mean,
well, they're saying that it wasn't public. It was an ex parte.
Right, the
denial
pleading wouldn't be public, but like, wouldn't on the docket it say order?
No, when we file, like in Illinois, if you're filing for non-domestic partners, it's under seal automatically.
And there's nothing on the docket that it was.
I can't even find it. I can't even look at it. Went on the counsel of record, and I'm having to go, like, because all of us lawyers are so used to pulling something off of the docket that I've tried on 2 different cases to get the other lawyer to send it to me, and they're like, oh, it's. They don't have it either, like, because typically those are filed initially by somebody acting pro se, and then they hire a lawyer. So, like in Cook, the judge's clerk sends it to me. I can't even see what happens. Can't anonymous via anonymous.
I mean, I don't want to say getting a ex parte order of protection or protective order is like indicting a ham sandwich, but when you don't have somebody there on the opposite side,
it's pretty damn
presenting a defense, it speaks to the weakness of the allegations that were put forth.
That's why I'm saying a judge is going to read this and be like, oh, I see. These people are pretty upset they couldn't get a what do they call it? Prevention order.
Yeah, like a protective order, I think.
Well, this says harassment prevention order.
Oh, yeah. Okay. That's what they call it there.
Then on January 6, 2023, McCabe traveled with her husband to attend their children's sporting event in Billerica, Massachusetts.
I'm not fucking with it.
It sounds like they're about to tell us how this is all petitioning activity. Kearney traveled to the same event at Read's behest. Where are the facts? A lot of this can get. First, I would come in to strike every allegation that doesn't have a factual support for it, that isn't based on, a logical inference from the fact.
Or evidence.
Right. Or evidence. Yeah, because when you're pleading a conspiracy, at least in most states, I obviously from the length of this pleading, it's a fact pleading state. You have to actually put in the facts, but they actually have to be facts, not you just saying stuff. This is not a verified pleading, is it?
I mean,
not at least at the top. It's not called. I forget where we were because I scrolled up.
You were down at
50 something.
53 at Billerica.
Yeah. Kearney traveled to the same event at Read's behest with the purpose of accosting the McCabes, which he did in a video that he posted online. Kearney then wrote a blog post about the interaction stating, Jen and Matt McCabe do not deserve to live a normal life and pretend they weren't involved in murdering a Boston cop. In a subsequent video, Kearney again discussed his harassment of the McCabe family, stating, I went to her kids' lacrosse game and made a scene there and got kicked out because I kept calling her a cop killer. Link. On July 23rd, 2023, Kearney met with Read and Jackson again in person. The purpose of this meeting was for Read, Jackson, and Kearney to meet with a national NBS news correspondent over dinner at a steakhouse in downtown Boston to discuss Read's criminal case. This meeting occurred the day after a rolling rally organized by Kearney took place, where nearly 50 cars drove in tandem through the streets of Canton, expressing their support for Read. Thank you for putting in and making clear I was engaging in
petitioning.
Right, I was saying like right, petitioning activity.
Yeah.
During the rally, Kearney stopped at the homes of Brian Albert and McCabe, who was home at the time, shouting into a bullhorn that Brian Albert and McCabe were covering up O'Keefe's murder. Petitioning activity. Kearney's behavior at the rally enjoyed the support of Read and her legal team. Indeed, the day of the rally, Yannetti messaged Kearney, "Thank you for your continued support."
Ooh.
Well, I mean...
Ooh. Well, you're welcome.
You're right.
Okay.
Best. The next day, Kearney hosted his weekday live show on YouTube. Weekend. He had a schedule. He did it every day. You could paint a conspiracy with the president of the United States that every time the president went on and ranted about something, within a couple of hours to a day, Kearney was on talking about Karen Read. And so therefore, the signal that he got from the president when he would say X, Y, and Z meant that he would get on and rants about Karen Read. Tie it to anything because he's doing it all the time.
He's got a very set schedule. Like he does his shit Saturday night.
Well, I know, or he's doing it Saturday night, but also whatever. The next day, he hosted his weekend live show. Look, I'm pooping myself out. During his show, Kearney stated that Jen McCabe killed or helped to kill. Let's keep it a buck. That's what she did. What? She killed John O'Keefe. Let's keep it a buck. Is that like a saying? Let's keep it a buck.
I have no idea.
He proceeded to question why O'Keefe's family was associating with McCabe's by stating, Jen McCabe killed her uncle, and then you're escorting her to the fucking orientation? And Jen McCabe killed your son. She fucking killed him. Because guess what, assholes? That's what he thinks happened. And you're never, ever going to prove, unless there's some message they're building to here, if there's a text that says, I fucking know she did that shit. I never thought those people were involved at all. Give it the fuck up right now. On August 9th, 2023, Kearney published part 96 of his Canton cover-up series. He began the blog post by explaining, the movement for justice for John O'Keefe and Karen Read continues to grow by the day. Petitioning activity. Although Turtleboy was the first media outlet to really dig deep into the story, it has taken on a life of its own, independent of our award-winning journalism. The Facebook group dedicated to discussion of this topic has nearly 20,000 members and is one of the more active groups you will see on the platform. Petitioning activity. His post, Kearney bragged about the fact that he was able to amass his followers, well over 100 cars and at least 200 to 300 people scattered everywhere. Petitioning activity in front of the McCabe home. He included pictures of himself wearing a free Karen Read t-shirt next to someone wearing the t-shirt sold by Kearney. Petitioning activity. Kearney Lambasted.
Lambasted.
Oh, I was like, wait, lambasted?
What?
Lambasted? I need cheaters. I can't find them anywhere.
Lambasted.
Lambasted. What is lambasted? Like just blasted?
It's exactly like lambstering. It's where you put somebody on blast.
Yeah, figure. Lambasted. The Canton police chief by stating, oh, wait, he voiced out concern for the chief of police petitioning activity. It's disgusting and pathetic that this public official is treating a cop killer like the victim of a crime. This is a problem. The McCabes and the Alberts are treated as royalty in this town, and they know that the police will go out of their way to protect them. This is why they felt emboldened to kill a man, frame a woman, and think they could get away with it, Kearney stated. It's painfully obvious to anyone with a brain that the McCabes and Alberts murdered John O'Keefe. Clearly, blatantly petitioning activity. On September 5th, 2023, Kearney directed remarks in a YouTube video towards Chris Albert, the father of Colin Albert. And this one's called Canton Citizens Revolt at Select Board Meeting. Wait, is that one? Petitioning activity. After Chief Rafferty blames peaceful protesters, you pledge yourself into a
petitioning
fucking
activity.
Petitioning activity.
Anti-slap motion.
You just can't even deny it or avoid it. It's called Canton Citizens Revolt at Select Board Meeting. After Chief Rafferty blames peaceful protesters for making Jen McCabe feel unsafe. You can't get more
petitioning activity than that.
Right. Oh, boy. On September 5th, 2023, Kearney directed remarks on YouTube towards followers towards Chris Albert and the father of Colin Albert. He bragged, I go down to your pizza shop and I stand out there for an hour and yell shit about your son. I'll just shit all over your child, Chris. I go down there and I shit all over him and I accuse him of some of the most heinous things possible and I affect business. People don't want to go into your business because of the things that I'm saying. I'm telling cars going by what your family did and what you're being accused of and what you've done to cover this thing up, what a scumbag you are, and how you don't pay your bills. Still petitioning activity. He's literally trying to bring public attention to the fact that, let's assume for the purposes of this, these people are involved in a murder, hiding a murder, and covering up a murder. And they want to tell people, don't do business with these murderers who are working with the police to petitioning activity.
Well, Chris Albert's not a plaintiff.
I don't care. He's talking
if he really paid his bills, maybe that would be some defamation. Hey, man, I pay my bills. Here's all the proof. I've never missed a payment on any of my bills. There's some defamation.
No, but he says, I go down to your pizza shop and I stand out there and I yell shit about your son. So he's talking to Chris Albert.
Yeah. So I said,
right.
But then he said, I'm telling cars going by what your family did and what you're being
murdered somebody
of and what you've done to cover this thing up and what a scumbag you are and how you don't pay your bills.
I'm sure he had some reason to say that. He must have been behind on something. Maybe he filed bankruptcy. Who knows? But I'm sure there was some reason that he said it.
Hey, man, the truth is an absolute defense.
I'm sure that at some point in time that fucker didn't pay a bill anyway. So, and hey, I don't even really have, I'm not convinced these people killed anybody, covered up anything, but, this thing is a giant piece of shit, or at least it should be. And if it's not, then the law needs to be rewritten. By September 2023, Karen Read's team was concerned that the police were potentially going to charge Kearney with witness harassment. If that were to happen, Read's counsel, Yannetti, expressed, quote, concern to Kearney that if that happens, then a judge prohibits you from having contact with witnesses. This prospect concerned Read, Yannetti, and Jackson since they feared silencing Kearney would impact the defendant's campaign against the plaintiffs. Wow. So now you're just blatantly making up lies about Yannetti and Jackson and just, it's like the whole thing. This is their protected petitioning activity. Like this document is the plaintiff's protected petitioning activity. But if it's complete and total fucking lies, then there should be ramifications for that. They're literally doing exactly what they're blaming the defense of doing. It's insanity to me that they don't see it that way, even while they're drafting it. They know they have no factual basis to say that. It concerned them, or they're just letting you know, like he didn't put the sentence together, right? Yannetti expressed concern to Kearney that if that happens, then what's with the gap? Why are you associating the concern with the following sentence? And even if that was his concern, hey, I'm concerned for somebody who makes their living reporting and interviewing witnesses and blah, 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 that if you get slammed, you should know you might not be able to talk to the witnesses, might not be able to have contact with them.
Are you talking about the gap in the parenthetical concern, and then a judge prohibit?
Right.
Are you implying that there was a little cherry picking going there?
Yes.
At some point, David used the word concern.
Right.
And at some point, he said the thing when he is explaining.
Yes.
The judge prohibits you from having contacts with the witnesses.
This is exactly what I'm saying.
Oh, yeah.
Oh, and how in the hell these plaintiffs' counsel don't, as they're drafting the words, think, well, we're really doing exactly what they're saying that they're doing here.
I mean, context matters. Context matters.
All right. So the prospect concerned Read, Yannetti, and Jackson. Why is Jackson in there? What the fuck did Jackson have to do with it? Now Jackson's getting thrown in the mix. Since they feared silencing Kearney would impact the defendant's campaign against the plaintiffs, now they know what these guys feared. You can't make baseless, unfounded allegations and then say we've stated a cause of action because we said the words. I mean, I just hope they've got to pay their lawyers. I don't know. So,
I mean, it goes to what I was saying in the beginning. If there's, look, I wouldn't consider, if you're looking at like the Alex Jones things where they got $1.4 billion, like that dude had deep pockets. Like his following is millions of people on followed his shit, whatever his channel.
I already forget. What did he say
it was like the Sandy Hook thing.
Oh, right. That the Sandy Hook was a.
So the point being is that Karen and Aidan don't have the deep pockets. Like when you're filing a suit, like the first thing they teach you in law school is you need to make sure that you're suing somebody that has deep pockets. Because if that's the intent, to recover the money, if they don't have the money,
have an avenue towards it.
You're not recovering shit.
I don't think they actually teach us that. They don't teach you anything practical.
They taught it in my first day of contracts. They said that. You must not have been in the contracts class.
I think I was.
Well, then you weren't fucking listening, sis. I don't know what to tell you. Which would
I'm
not
sure I wasn't.
You were thinking about, when is it time for a smoke break?
Yeah.
Some shit like that. So which leads me back that this is punitive. Like this whole thing isn't about recovering money.
No, it's definitely not.
It's about forcing them into litigating this thing and spending whatever money they've made.
It's exactly what the anti-SLAPP is designed to prevent.
Right.
I mean, it's a different context than your black and white one where, you're out petitioning and they want you to stop, so they start doing this shit. But it's the same thing. You're petitioning to have killers investigated and declared killers because you're 100% sure they're killers. And by trying to even allege that one part of this conspiracy lied to you to get you to believe that, I'm not saying that is true. I'm saying this is the words that these people wrote down. It's not a fucking conspiracy.
I mean,
It can't be.
If they're under the misapprehension that Aidan doesn't love this thing, they're out of their fucking minds.
Oh, of course.
Like this just
It's
bought
so
him
stupid and
3 years of
ridiculous.
content.
Yeah.
Do they think that Aidan's not going to be on every
I'm sure he
single
probably is
week
already read it on.
until trial? Like they fed the beast with
Right.
this.
They're literally helping him pay for his own defense against this shit.
They're helping him pay his mortgage on the house.
Y'all are fools. Whoever told you this was a good idea was
backfire.
stupid.
What a incredibly stupid.
You're literally
this
paying for him to defend.
And they're going to get the
this
opportunity to like really, like, I don't know if in the first civil suit, which Aidan is not a part of, the one that Karen.
Oh, now they might as well just.
And then they countersued. Like,
he's going to be able to sit in every deposition.
He's going to
get. He
will.
He's
going to get to like. Oh, he's 100% going to sit.
Oh yeah.
And then he's going to run onto his show.
Oh,
and he's going to talk about the depositions. Right. Well, we wouldn't otherwise get to hear what happened in the depositions.
Right.
Now we do. Now we do.
You don't get to initiate a lawsuit and then want your shit private.
I said this 2 fucking years ago about like them.
I know.
At him filing a defamation suit. I'm like, good luck with that shit. I'm like, that's
they literally proved that he, on their words, I'm not saying this is actually true, but there's something called pleading yourself out of a cause of action. You put the words in here that he was lied to believe this story hook, line, and sinker, and you're trying to sue him for lying about the story. How could he be lying about something he was told happened in a grand jury by multiple people? Idiots. You don't need to put in the whole kitchen sink. Could have left that one out, but you pled it in. So on its face, some of this shit should fail. And maybe I'll end up with egg all over my face because it won't. But I don't care. I'm worked up. But it should. No, I mean, under conspiracy law, it absolutely should end under defamation law. You can't lie about what you've been lied to, and not just the guy on the corner told me that this happened. I've been told by who I'm led to believe.
Hey, it's as simple as this. If neither of us have read this complaint all the way through yet, if there better be a paragraph down here somewhere where Karen tells Aidan all this was bullshit.
Right.
Like I hit John. Like we don't think that that happened in the house. Like that's got to exist.
Right.
In
if it doesn't,
if it doesn't, I don't know what we're doing.
No, me neither.
Other than paying for Aidan's mortgage.
Are the people still enjoying this? Because we're going on and getting like, 3 pages in another 40 minutes.
All right, here I'll pick it up. I'll read faster than you. You can just rant while I'm
all right. I was enjoying myself.
I know you can still rant. People love the ranting. Where are you at?
I
think it was
60. I wasn't even done at the end. Let me finish 60.
Okay.
So Reed, Yannetti, and Jackson are really afraid. And on September 9th, 2023, Yannetti messaged Kearney regarding the plaintiff stating, "These bastards deserve all the scorn we are giving them." With Kearney silenced, the scorn Reed intended to incite might diminish. What? So that's how they're. That's how they're
in our house. What's up, Mel?
Hey, Mel. So that's their big plan. that Yannetti and Jackson were so worried that Kearney was going to get silenced that with him silenced, the scorn that Read intended to incite, Read might diminish. What the fuck are you even saying? This is ridiculous. It is so ridiculous because Yannetti also believes this to be true. Can't convince me otherwise and can't prove otherwise. So for all intents and purposes, Yannetti believes this to be true. So when he says these bastards deserve all the scorn we are giving them, he's filing pleadings. He's fighting also to have this properly investigated. Independent of him, Kearney is also engaging in petitioning activity to get the world to know that, the police.
That's bolstering Aidan's belief
It's
that the House defendants killed John O'Keefe.
so crazy.
I mean, like that statement, these bastards deserve all the scorn we are giving them, only emboldens
the
Aidan's
truth
belief
of the truth.
What happened to John O'Keefe?
Well, they better get to it. They better start telling me all these text messages where they all know it's a lie and it's a scam. All right, you're up.
All right. In addition to using Kearney as a tool to seed the public discourse with defamatory material, Read, through her counsel, also hired a private investigator, Sarah Ness, hereinafter Ness. Ness had previously worked with Jackson in connection with his representation of disgraced sex offenders. Disgrace. Like,
I can't look at the chat. I'm missing stuff. This is all so crazy.
So
what happened?
Yeah, they're putting Jackson on blast because he represented Harvey Weinstein. So who is a piece of shit?
But still, you're
it's a job.
Is the audience the judge? Is the audience the judge? Clearly not the judge, because the judge isn't taking kindly to them shitting all over the jury verdict, and now seemingly to try and
shame a defense attorney for being a defense attorney. So he previously worked with Jackson in connection with his representation of disgraced sex offender Harvey Weinstein, and was deployed in that case to discredit the victims of Weinstein's crimes.
Wow.
So on September 17th.
Wait. Let's see comes from a thing.
24.
See Ronan Farrow, Harvey Weinstein's army of spies in the New Yorker. So anything that somebody writes in the New Yorker is fact?
I mean, New Yorker's pretty.
I know, but you're saying from this.
The New Yorker's not the Post.
No, but you're saying from this, Jackson, intentionally hired this investigator who was told to spy on, victims.
They're imputing the fact that Alan Jackson has high-profile clients that have done some awful shit onto this case because of how he handled the defense and investigation of Harvey Weinstein's case. So now what's happened here is he's employing the same techniques. That's what they're implying here.
That's what I'm saying. This isn't written for a judge, because a judge is going to say, that's just going to piss off a judge. That's it. That's going to see this whole, every time they put something stupid like this in here, and there's been a lot of it, I think it's pissing off the judge personally, but I guess we'll see. Is he gone? No, no, that's not happening. Oh, he's back.
Oh, hi. Oh, I lost the document too. I did that thing where I used 3 fingers and
I didn't like my face all big.
Sorry. All right, hold on. Let me pull. On a Mac, if you use 3 fingers and you swipe up, sometimes it shuts all the shit down. All right. All right. So on September 17th of 2023, at the direction of Read and Jackson, Ness visited the home of Higgins. Read and Jackson directed Ness to question Higgins and other witnesses using tactics similar to those used against the victims and witnesses in the Weinstein criminal trial. While Ness confronted Higgins, who, oh, gee, is it like, did they use like a Read technique? Did they use the Read technique? Did the investigator
I mean, how bad
on Higgins?
How bad was it? Did it go as far as what every cop does in every interview around the nation and is trained to do?
That's a lot.
That's a lot.
Okay, so Ness is employing the Read technique, it sounds like, to question Higgins and other witnesses using tactics similar to those used against victims and witnesses in the Weinstein criminal trial. While Ness confronted Higgins, who Read and her counsel knew was represented by counsel at the time. What? Okay. And like, this isn't a criminal investigation. Like, what are they implying? Like, is there some prohibition?
Right, and they weren't in the middle of a suit against each other. So what's the issue?
I don't know. Read and her counsel watched from a blacked out.
Better question. Why did Higgins need fucking counsel?
I don't know. Maybe because he cracked his phone.
Oh, right.
Threw the phone and the battery in a fucking
military. Maybe that.
Something weird like that.
Maybe that.
A strange thing. I don't know. It's a weird thing to do. With Read texting Kearney in real time about Ness's efforts. Quote, sorry, in the car with the lawyers, stirring shit up again. Okay. Ooh, damning.
So they just get to put that sentence in and tie it to what about her stomach issues? She could have been stirring shit up again.
I mean,
just saying.
Okay.
You just put that there and tie it into your rest of your sentence to make it this is not convincing a judge, you idiots. It might convince the people like, wow, this is all very suspicious. Like someone who doesn't know much about this case or anybody on the other side, I guess.
Want to hear objection before I hear a word out of your mouth. Objection. Overruled. Sit down.
Oh my God. I've been working nonstop now, but if you're still here, I've been trying to I thought I watched most of it, but I think then I finally fell asleep and I never heard that part yet.
What?
No, I haven't gotten through the hearing.
Oh my God. It's Tressler, man. The guy's a fucking legend. It was the only reason I was contemplating covering that case because I love Judge Tressler so much.
All right, Read.
I told you, if you're going to make words, you say objection, overruled, sit down. It's so fucking good, man. All right. Following Higgins' refusal to cooperate with Ness.
Wait, it said you were at 63, I think.
Oh yeah. When Higgins refused to speak with Ness, Read texted Kearney again, this time seeking the address of Sarah Levinson, another witness who would ultimately testify against Read. Following Higgins' refusal to cooperate with Ness, the defendants directed additional defamation and defamatory conduct at him.
Defendants? Who are the defendants? I'm sorry. Following Higgins directed at him. All right. Sorry, keep going.
As a federal law enforcement special agent with covert undercover responsibilities, Higgins suffered profound damage to his career as a result of the defendant's false and widely publicized statements.
Stricken.
Higgins was involved in O'Keefe's murder. In addition, due to maybe it was him cracking his phone.
I mean,
on a fucking base and driving back to the fucking.
If one of his suspects did that
in the morning, I'm gonna move some cars around at 1:30 in the morning when I'm shit faced.
If one of his suspects did that, he'd be going in to get a warrant, talking about all the consciousness of guilt evidence.
For real. I
mean, this is so stupid.
So that Higgins was involved in O'Keefe's murder. In addition, due to Read and Kearney, God, I'll never stop reading his name properly. Kearney's defamation. Individuals have traveled to Higgins' residence for the purpose of taking photographs and videos. Higgins has been surveilled, and individuals inspired by Read and Kearney's defamation campaign have trespassed and vandalized his property. Kearney
Aren't we
himself,
all part of this campaign then? We are all part of this campaign yet then. I mean, yeah, not as effectively as Aidan, but am I a co-conspirator? Is Mel a co-conspirator? We all have the same plan. You know what that plan is? To expose a bullshit fucking prosecution.
Yeah, I know.
So
Awful investigation.
we're
Again, I said it at the beginning
conspiracy.
of the show, who should be on trial is the Canton Police Department for their just repugnant investigation into this case. If they would have done anything normal, if anybody in this audience or this chat thinks for 1 second, if they found a dead body on your front lawn for a person who is invited to your home, that they're not coming into your house, you're living in a fucking dream world.
No,
I'm here to
dream
tell
world.
you are living in a dream world.
Yep. All right, keep going because we've got another.
Brian Albert got preferential treatment because he was a Boston cop, plain and simple. They didn't come in that house.
Yeah.
They didn't search that house. If they would have done anything, if they didn't do anything and they're clear, I would have been like, yo, yeah, of course, come on in. Yeah, you can go in the basement. What do I give a shit? Yeah, he never came in the house. All the things, all the normal things that would happen if you had nothing to do with the poor dead cop lying on your front lawn. You'd be, yeah, have at it. I got nothing to hide, bro. Come on
64 stricken. That's one of that paragraph stricken. It's irrelevant.
Yeah, the defamation campaign have trespassed and vandalized his property. Kearney himself has personally harassed Higgins by visiting Higgins' residence on multiple occasions for the purpose of confronting him and generating content to be published on platforms Kearney controls.
Petitioning activity.
So on September 19th of 2023, Kearney hosted his weekday live show. In his show, Kearney stated, "What I'm saying right now," I want to try to do my fucking Aidan impression.
No,
what
don't
I'm saying
don't,
right
just-
now is I'm not saying this is a matter of opinion. I'm saying this is a matter of fact that Jen McCabe participated in killing and planning to kill and cover up the murder of John O'Keefe. I'm saying that is not my opinion. That is a fact.
Well,
Quote unquote.
that,
I mean,
again, he thinks it's true. And I mean, they're not going to be able to prove that he had a reckless disregard for the truth.
that right there, truth is an absolute defense.
Right.
And this is a burden shift case. Defamation, the plaintiff is going to have to prove falsity.
And that it was reckless for Aidan to think it was true. And they pled themselves out. As far as I'm concerned, maybe I should go listen to Mel. Mel's
When
done
they
a lot of
fully try this case and the defense puts on the entire case that they have against the House defendants, all of it's coming in.
No,
All
but
of
I'm
it's
saying they
coming in.
pled themselves out of this paragraph right here, you guys.
I understand. Let's assume arguendo.
Wait, let
it
me
makes
just
it
tell-
the trial.
Right. Let's just tell the people why. I think probably everyone knows 65 would be problematic in your typical defamation, lawsuit, because he is saying this is not my opinion. This is fact, and opinions are always out as far as defamation is concerned. So, but again,
I mean, that's why most media uses the word allegedly. It's your safe harbor word. It's like, oh, allegedly. Fucking killed that person, allegedly.
and he says it. So yeah, keep reading.
So he went on to taunt McCabe by exclaiming, "Jen McCabe participated in killing John O'Keefe. So sue me. Why don't you just sue me? Because you did it. Because she did it. That's why, because she did it."
And you know why that's could also be petitioning activity? Because thinking a lawsuit would bring more light to this and more attention and more people standing up and demanding accountability.
I mean, at that point in time, Aidan's all in. You know, I mean, he's a, and again, like that particular thing where he's inviting the lawsuit should have told him. And I'm talking about the House defendants
and the lawyer that
counsel.
drafted this. Right, exactly.
This dude, like, this guy's begging you to do it because he understands that the discovery process in the civil case is much broader. They're going to be able to get much more shit than they could ever get.
Well, but and like we said, it at the time that was made, it would have brought more attention to the case, more eyes on it, more
100%.
petitioning activity.
Well, it's doing the same thing right now.
Yes, it is.
It's doing the exact same thing right now.
And they're paying for his defense. Good job, plaintiffs.
So during the same live show, Kearney also called McCabe's brother-in-law, Bob Galvin, after someone sent Kearney $10 to his Cash App with Mr. Galvin's number. Kearney left a voicemail for Mr. Galvin in which he claimed, among other things, your sister-in-law, Jen, she done killed that motherfucker. End quote. Thrilled by the level of exposure and overall impact that Kearney's publications were having on Read's defamation campaign, or just thrilled by the exposure and overall impact it was having on his business. Like, he's like, this is fucking amazing.
Or her case.
This
right.
is fucking amazing. Like, I've been able to like build my brand on this case.
No, yeah, but this is Read messaging Aidan, Karen messaging Aidan.
I'm talking about that first sentence. I haven't even gotten to that yet. I'm just talking about.
Well, but you have to finish it because
if I'm Aidan, I'm happy.
It's not Aidan. It's Karen.
I get it.
Okay.
Okay. So, but Aidan's thinking the same thing.
I gotcha. Go on.
All right. So Read messaged Kearney through Signal on September 29th stating, look at what you've done to their reputations and my jury pool. So Chris Albert's business is the next casualty. Just a matter of time. End quote. Read was referring to the public degradation of the reputations of, among others, the plaintiffs.
Again, this is, if you look at it from the other side and she believes these people have framed her, killed the love of her life, and are working with the government to hide it and all of this, that his reputation should be the next casualty. So I still don't see conspiracy. Now, look what you've done to their reputations and to my jury pool. That sentence, but it's just a byproduct of his petitioning activity.
Right. I mean, it's like it's a common sense fucking observation, know, and byproduct of it. It's like, that's not indicative of a conspiracy. That's indicative of somebody saying, okay, everybody in Canton now believes that the House defendants are the ones who did this, not because I made it up, but because of all the shit that you put out there about all the weird shit that happened that night. Like, without all the weird shit, nobody's buying it.
Right.
That's like that's the part that they keep forgetting about.
Is that the story makes sense?
They were just normal folks. There was all the weird shit. The fucking butt texting and the fucking cracking,
deleting and the calling and
all of that shit. It exists in the world. Without that, if you subtract all of that, none of this is taking place at this point.
I don't care if
it all exists, and none of it's made up. The only thing that's ever been questionable to me, and it's still questionable, is the 2:27 a.m.
But guess what? When Aidan's told it as though it's concrete and all the other things, there is no disregard, reckless disregard for the truth. There's, oh yeah, this shit is the truth. And they've pled themselves out again, as far as I'm concerned, on that issue. But I wanted to point out, you know how we've been saying they just like pick something close in time and then say it relates to this thing here, this assertion here. Karen saying, look at what you've done to their reputation, 2 exclamation points, and my jury pool. He sure as shit has nothing to do with the $10 Cash App phone call to
Bob
Mr.
Galvin.
Right. Come the fuck on.
Around the same time, Read and Kearney became administrators of the Facebook group Justice for Officer John O'Keefe and Karen Read, Turtleboy Official. As administrators, Kearney and Read maintained complete control over the Facebook group, including the ability to approve or deny posts, delete posts or comments, and approve or deny new members. The group became a feeding ground for defamatory and harassing posts made regarding the plaintiffs. Read personally posted in the group on several occasions, including instances where she shared confidential information regarding her criminal case that had not been previously made known to the public.
I don't know what's confident. Was she under a gag order, her, the defendant?
No.
So what the fuck is confidential? If you don't think people can, if they want, lawyers tell you not to talk about what their case and the evidence against them or not against them, or they can do it's. This is not a there is no world where a judge reads this and thinks you have stated a logical inference from the facts that this was a conspiracy to defame. Meaning the intent of your plan, you can't defame when it's the truth. Again, they pled themselves out on that part. Can't be a conspiracy with one person. Their allegation that Karen knew she did it, so she knows it's all a lie, only works with Karen. She can't be in a conspiracy with Kearney. Point, period, the end. Unless, again, you and I haven't read this. There's some text about to come, some messages. Did
Melanie finish this whole thing today? There's no fucking way. Did she finish this?
She probably reads it a lot quicker than we do.
I mean, Mel's known to commentate. She stops and commentates quite a bit. That makes me.
We're gonna get to the end.
We're gonna do like the statement of facts before we get to the counts, and then we'll finish it tomorrow. Okay. We can't do it all. Like, we're already at 3 hours. It's
no, I say we stop at the next section we hit.
What?
All right, come on. Are the people still enjoying it?
I have no idea. No. All right. On March 12th of 2024, Kearney posted a 2-hour recap following one of the last court appearances before Read's first trial.
Again, if you're following a trial, these are the key points in time. I'm sure Melanie did that. You fucking co-conspirator. You went live every time there was something happening in court.
Jesus, we did too. Are we in trouble, babe?
Oh, we I mean, not this early.
Yeah. We called them murderers because, in the video, Kearney stated, we called them murderers because they are. They murdered John O'Keefe, and I will not shut up about that. You can call them witnesses all you fucking want. They murdered John O'Keefe. That is a fact. It is undeniable, and we don't know who delivered the fatal blow, but they all fucking did it.
Petitioning activity.
So Kearney attempted to justify his harassment and defamation of the plaintiffs by claiming that they deserved it. For example, Kearney admitted that he harassed McCabe at her daughter's lacrosse game and attempted to justify that conduct as follows. Well, guess what? Jennifer McCabe murdered a Boston police officer. She doesn't have a right not to be asked questions in public about that. You murdered somebody. You don't get to just walk around like none of this happened.
Petitioning activity.
So before launching the defamation campaign with Read against the plaintiffs, Kearney's YouTube channel only had about 25,000 subscribers. Before the first trial, Kearney's followers had ballooned to 70,000 YouTube subscribers.
These people can't be this stupid. I know these lawyers aren't this stupid, but this is stupid.
The profit model.
All right, here's them trying to take this out of petitioning activity and say the real motivating wasn't petitioning.
It's the anti-slap
It's the obvious anti-slap attempt.
The profit model.
The anti-slap.
So Kearney's willingness to work with Read and his conduct is based on twin motives: greed and fame. Kearney's business model relies on his ability to attract an audience by spreading outrage and mistrust, including, most centrally, through his defamatory statements about the plaintiffs. It is a very lucrative business model. Kearney and Read have built an audience and celebrity by spreading these false narratives.
I think Karen had the celebrity by being falsely charged with the crime.
Okay, so Kearney holds himself out as a trusted reporter, regularly referring to himself as an award-winning journalist and a truth teller, when, in fact, he is nothing more than a willing purveyor of and vessel for defamatory material that Read fed him to publish for her own selfish purposes.
Oh, her own selfish purposes.
You can't defend yourself in this country, woman. Don't you know that?
No, but
what's wrong with you?
Again, a conspiracy requires them to have the same motive. They have to be motivated to the same ends.
I mean, are these attorneys, again, have they, I'm assuming they never tried any criminal cases. Like, are they saying that you can't put forth a third party culprit defense? Is that what they're implying?
Yeah, that's what they're implying.
It seems like
definitely can't tell people about it, and you definitely can't get excited when people take the story and run with it.
File a Rule 17 motion. That's for fucking sure. If it's going to bring up people that aren't the defendant, it's a no-go. Sorry.
Only the cops can do that kind of thing. They're the only ones that can accuse on reasonable grounds to belief. The rest of us have to shut the fuck up and just.
Barney Fife would be making citizens arrest left and right. That's what would be happening here.
I mean, if this isn't reasonable grounds to believe, there's probable cause all over the place.
I mean, are they sitting there, and I'm talking about the House defendants, like acting like there was nothing bizarre about, right? Well, the House now plaintiffs, that there was nothing weird about the shit that happened that night.
Come on.
Are they honestly thinking that?
You mean if they didn't actually engage in like a whole murder cover up? I still think no. I mean, anybody with eyes can see how suspicious it all looks.
Yes.
Again, they're doing it right here, just misconstruing and sticking shit wherever they want to, and squeezing out some kind of bullshit, story for their petitioning activity of this damn complaint.
So he is the vessel for defamatory material that Read fed him to publish for her own selfish purposes. Once Kearney captures his audience's attention with outrageous claims, he exploits their anger and mistrust by urging them to pay him money in exchange for products that echo the false worldview he promotes. What he really does is he puts himself in fucking absolute peril because he can't fucking keep his mouth shut. Like what Aidan is, I was thinking about this today when I was in the shower, which is when I do my best thinking. He's the equivalent. People pay him because he's the analogy is that he's a boxer. I pay to watch boxing because I want to watch people get punched in the face and knocked the fuck out. And Aidan is a boxer who puts himself at risk. Aidan fucking damn well knows that this was a likely outcome. We just saw him screaming at Jen McCabe to sue his fucking ass. He knows.
I mean, 100 and some years, he might not have anticipated that.
That's the one. That's the thing that I said that he wasn't anticipating. But he got up, dusted himself off, got himself a fucking lawyer, and now has become a champion for free speech. And it's against a behemoth. It's a David and Goliath. He's the underdog. Everything that Aidan does is with purpose. People that think that Aidan's some kind of fucking moron are out of their minds. This guy knows exactly what he's doing.
He plays one on YouTube, though.
I mean,
Sometimes.
it's all a fucking. It's
Some of it's his
when I watch his
shit.
shit, it's like watching a Saturday Night Live skit. Like that's what
Right.
I feel like, with
All right, keep going.
all right. Okay, so in his interest or internet-based shows and content, Kearney hawks merchandise exploiting the Canton cover-up, his dishonest characterizations of events, a Boston cop possibly being involved in murdering another cop, followed by an elaborate cover-up designed to frame the murdered cop's girlfriend. A design featuring a Massachusetts license plates with the word framed as the number, and a t-shirt featuring the text of a Google search that Kearney has repeatedly lied about, to name just a few.
Petitioning activity.
Totally.
They're literally proving in almost every count or paragraph petitioning activity. So you just said he's selling this shit, but it's all shit to shine a light on the fucking thing he's standing up against because of his own purposes and not because he's just a reporter.
And he's making a few bucks at the same time,
which is the American way.
That is the American way. So Kearney consistently hustles his followers to donate directly to him on his homepage. And
strike it.
I mean, dude, like, are these guys, do they hate fucking capitalism?
They hate well-written complaints.
Because that
well thought out,
like a rented mule. Like anybody that's a content creator that does a lot of content knows how much work this is. Like
just sitting here is getting worky,
dude. Like I'm sitting here like wishing like we were getting the fucking kind of supers that Aidan does. It's like whatever he does, he's got the magic sauce. It's like,
all right, well, you're gonna be that outrageous. You're gonna get some people throwing money.
You're a boxer. You're taking the punches. People pay you for it.
Wow.
His YouTube features a defense fund where followers continue to send his money in his pursuit of defending free speech. It's true.
That is true. You're proving it. House plaintiffs.
I don't know that he signed up for it, but he certainly leaned into it. And that's exactly what's happening in that case.
All right.
And during his live streams, he shares the names and messages of people who donate to him directly while watching his content. For example, during one live stream, he listed that Stephanie sends $10 and says, Brian Higgins, car front of mailbox. How does that work? Help. How does that work? Help. Thank you very much, Stephanie. Jim Ferris Bueller sends $5 and says, hey, Liberace, that shirt's going to irritate your nips.
Okay, well, when we get to, we'll keep going.
Jason EMT sends $5, no comment. Thank you, Jason EMT. Carrie sends $5 and says, what news station is covering the trial? All of them.
Petitioning activity.
Brooke sends $250. Says, like, why is the purpose of this to show that he makes money?
Yes, but guess how he's making it? Putting it out there through his petitioning activity. Yeah. He's got free Karen Read. It's just, come on.
Yeah, so he makes a bunch of money here with a bunch of people sending him turtle chats. After personally recognizing his followers, Kearney goes on to direct his other followers to donate to him at the link on his website or directly through Cash App. Ooh, wow.
Okay, we've just described every YouTube channel.
YouTube. You have just defined YouTube. Okay, so Kearney's followers buy subscriptions.
Oh no,
he got demonetized and had to come up with a whole nother way to make money off of YouTube so that he could still be on. It's like,
yeah.
Donate to him, purchase his merch, and continue to visit his website and YouTube page, all of which boost his attractiveness to advertisers. Well done.
And the issue to the public. Petitioning activity.
Yeah. Kearney has estimated his monthly income to be 45 to 50 grand, which he attributes to his defamatory discussions of the Read case. Kearney publicly defends this corrupt business model by explaining, well, It's capitalism.
We just said that. I mean, is this the foundation for their consumer fraud claim? Is that what it is? Is it?
I don't wait. There's a consumer fraud claim.
Yes, it's the last count.
Oh my God, really? Wow. If he creates a service that people think is worth giving their hard money to,
Unfair
that's
business
capitalism.
practice through monetized defamation.
Oh,
Unfair business practice.
okay. That's their choice. He claims that, quote, people want to give him money. People want to buy Turtle Club subscriptions. People want to buy stuff from the store.
Strike it. Strike the last 17 paragraphs. This is, I'm serious. Don't know what, well-trained, intelligent lawyers did writing this strained attempt to slap the anti-slap is a fucking like nosedive.
In coordination with Read and at her behest, Kearney spread elaborate and false narratives about the plaintiffs because doing so attracted attention, personal notoriety, and a buying audience. He deliberately stokes social anxiety and political discord in his listeners because distrust in government and cultural tribalism motivates those listeners to buy his products. Kearney also sought production and movie deals to further monetize his highly public defamation and harassment campaign against the plaintiffs. On July 1st of 2023.
I need to say something. This could be the lawsuit between all, I'm going to say all, but I don't really mean all, but the Republicans versus Democrats, for instance, and one side saying they have been lying and defrauding everyone about the fraud, about the vote being a fraud, and the other side screaming they are lying and telling everyone the vote wasn't, a fraud when it was a fraud. And people get on their YouTubes and they talk about how there's been voter fraud or not been voter fraud, and they get paid money for what the fuck is happening here? Like,
I don't know. Like I'm way, like it seems like we're done with the text messages.
Is this what CNN and Fox TV and MS News do every day? Everybody's working up everybody about either government or politician fraud on this side of the aisle versus that side of the aisle, and then making money from commercials on it. And then they get a bunch of people who subscribe to their YouTube channels and buy subscriptions to their written what the fuck?
Kearney also sought production and movie deals to further monetize his highly public defamation and harassment campaigns against the plaintiffs. On July 1 of 2023, just 3 months after Kearney began working with Read to disseminate her false claims and harass witnesses, Kearney reported to Jackson that he had received an offer for a Karen Read documentary from B17 Entertainment, a California production company.
Oh no, he shared information.
Wow. The trial of Karen Read. So Read's first saga began with jury selection on April 16th of 2024. Kearney took to his live stream on April 17th and wondered, quote, if they can find jurors that aren't tainted already, end quote, because, quote, Turtleboy is everywhere. He proceeded to claim that they, quote, can't find a jury in the United States of America anywhere, any county, anywhere, end quote, because, quote, Turtleboy is too big. It's fucking like, it's hilarious. It's like, it's satire, like, obviously. On April 20th of 2024, Kearney interviewed an excused juror who had previously engaged with his content and had been a member of his Facebook group. She explained that when she arrived for jury duty, she saw free Karen Read signs all along the street and people wearing pink in support of Read. And
I wonder why. Could it have been his petitioning activity?
Yeah. And that she could hear the protesters inside the courtroom. She also said that everyone in the room said that they had previously heard about the case. During that same live stream, Kearney played a clip covering the courthouse from Court TV. He proceeded to verbally attack the host.
Right. So did Court TV.
who expressed dissatisfaction with the conduct of Kearney and his followers, claiming it was disgraceful for them to harass the O'Keefe family. Kearney said, referring to McCabe, "You know what's disgraceful? Julie Grant. I'll tell you what's really disgraceful is when somebody who Googled how long to die in the cold at 2:27 a.m., they refused to make it house long." In the pleading, because they wanted to make sure, they wanted to see and find out how long it would take for John O'Keefe to die in the cold. When a person like that shows up with the O'Keefe family and rubs their shoulders and starts a support group called Peggy's Angels, that's disgusting. Kearney went on to say that McCabe is sick and sadistic and twisted, and that he has, quote, "nothing but hatred for her, as I should, because I'm normal. I'm a rational person. Any rational person hates Jennifer McCabe and is disgusted by her because Jennifer McCabe is a pig. She's a pig. She's a cop-killing pig."
Right.
End quote. He proceeded to mock the court TV host again, saying, quote, "She supports a cop-killing pig like Jennifer McCabe, who Googled how long to die in the cold." End quote. On May 17th of 2024, following the first day of McCabe's trial testimony, Kearney posted to X that McCabe was a psychopath and that she, quote, "knew exactly where O'Keefe was dying in the cold on Brian Albert's front lawn. She plotted to put him there." End quote. On May 21st, 2024, Kearney published part 354 of his Canton cover-up series, in which he summarized the testimony of the plaintiffs and claimed that the plaintiffs, quote, "lied their way through their testimony." He claimed that, quote, "they all have nearly identical, well-rehearsed stories," end quote, which, quote, isn't surprising because they've had 2 years to make sure that they have them straight and their lives depend on the consistency, end quote. He also explained that, quote, "all of the plaintiffs were caught in lies at some point during their testimony," and that's a quote. On June 7th of 2024, Kearney joined the Morning Club YouTube channel to discuss the retrial after being praised for, quote, "literally creating all the fanfare surrounding Read's trial." Honey, what is that?
Petitioning activity.
Oh, yeah. So Kearney touted that people believed, in response to Kearney's coverage of the case, that the plaintiffs engaged in a, quote, "legitimate cover-up and a framing of an innocent woman in order to protect some of the most unlikable people ever." Like, it's not like they're trying to cover up and protect likable, nice people. Like, they're protecting Jennifer McCabe, who nobody likes. She's like a Disney villain. She's so bad. And you're protecting her, of all people. And that's a quote.
And I'm warning you, we're stopping when we get to the next header, period.
All right, you pick it up for a minute.
Okay. On June 22nd, 2024, Kearney hosted his weekend live show as Read's defense team began presenting their case. During the show, Kearney directed comments towards a member of the Albert family and said, "Your family murdered a cop, a human being, and then they covered it up and they blamed an innocent woman. This is not an opinion. This is fact. It's an undeniable fact. The bigger injustice is that John O'Keefe was murdered by the McAlberts." Finally, the McAlberts make it. "And left outside to die." Petitioning activity. In March 2025, HBO released a 5-part docuseries covering Karen Read's first trial in depth, which features interviews with Read, Jackson, Yannetti, filmed during Read's first trial. Episode 2 features the relationship that developed between Read and Kearney before and during trial. Yannetti admitted that they wanted media coverage of her case. Oh no, what defense attorney doesn't when it's good? Initially, there was no coverage, but according to the Yannetti, the Karen Read case really started to blow up when Turtleboy started shining a light on Karen's innocence petitioning activity. Yannetti did not disclose that it was Read and her team who recruited Kearney to disseminate Read's false statements. You have not established this thus far. You have not fucking even come close to establishing this with you even just being able to say words. You know why they haven't been able to? because they actually put so much of the messages in, whether with or without context. They literally disprove what they're trying to prove. And I just want to confirm, because earlier I said they don't have the same motive, and technically you can be in a conspiracy without the same motive, but you have to have the same goal. And if, as they're pleading, Read, who knew she killed a man, lied to Turtleboy to make him believe she killed a man, then they don't have the same goal, where hers is to cover up her knowing murder and falsely blame someone else, and his is supposedly to make all this money by saying this thing happened, because saying shit like this happened makes money, but all your facts demonstrate he had every reasonable belief that it was true. If not, maybe it is true. So, Yannetti did not disclose. Yeah. Okay. Sure. They recruited him. Read admitted that her lawyers said that she could provide information to Kearney so long as it was public. Okay. And advised her not to speak with him directly. Also, advice that your lawyer would tell you, because you have no confidentiality and something you say couldn't get twisted. So, of course, they're going to say, do not speak directly to the person who's always covering your case. You don't want your client speaking to the news. Nevertheless, she said she got nervous about who she was using as a third party. I wonder why. Now you might as well have just shat all over your earlier allegations that every time the third party spoke, it was Karen. So she ended up developing a direct relationship with Kearney herself. They started to talk about the case probably once a day, 5 to 6 days a week. And Read, however, failed to disclose to HBO that her counsel on her behalf, were directly communicating with Kearney at the outset of the defamation scheme, which you have literally disproven. Literally disproven. The same HBO series, one of Kearney's followers admitted that Kearney had spurred them to take action. Yeah. Isn't that all his petitioning activity? Another admitted that Turtleboy was the reason there were people outside the courthouse every single day. What is wrong with these assholes? Petitioning activity. The documentary features footage of Kearney conceding that his purpose in canvassing the communities and creating a daily courthouse presence was to affect the jury pool. Kearney's followers were so incendiary that the judge created a 200-foot buffer zone around the courthouse and ordered that no one carry any signs or wear any clothing, with the intent to influence what was happening inside during the trial. Nevertheless, Kearney's followers, who were steeped in his lies about the plaintiffs, showed up every day chanting "Free Karen Read" and wearing pink as a symbol of their support. Petitioning activity proven. The defense it's called pleading themselves out of a case, as far as I see it, up to E, which is where we will pick up next time.
Oh,
Got to take the people's questions, though.
Okay. All right. So we're on page 26 of 50. And it only took 3.5 hours. That's pretty good. Pretty good. All right.
Maybe we should read this beforehand, so we're not so shocked that we talk so much during the next one.
What do you mean?
Like,
No,
I think
I like that first blush shit.
Okay.
It's like, that's the best way to do it. Got to do it first blush. It's like, if you read through it, then, all right. So,
well, I see this one here, so I want to take it real quick. What's that say?
does this even need an anti-slap?
No, I meant the name.
Oh.
Op-top Auto-Pop-It?
Op-top-pop-it.
Ah.
Op-to-pop-it.
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 Does this even need an anti-slap? Failure to state a claim should do it too. I agree, but I wouldn't get, I don't know. I
But
again,
you're having to spend money to litigate
right. And you only have
failure
60
to state a
days.
claim. The whole point of anti-SLAPP is it halts the litigation and they deal with the anti-SLAPP. And basically it does the same thing. It gets rid of the suit and then they have to pay whatever fees that you've paid. So while you're probably right, a failure to state a claim would be a good move. You're going to probably have to wait until you're in discovery a bit. Like you're going to have to litigate the thing before you file that.
I wonder if they can file the anti-SLAPP and then
there's a
file.
timing aspect of anti-SLAPP. It's got to be within 60 days.
Yeah. They got to
So-
do that shit first. And then I would say motion to strike all the, see, but if they do a motion to strike first, then they can amend. So, I mean, they can amend no matter what, but I don't know.
All right. Yeah, let's go through and see if there's any specific questions and then we'll think.
I honestly do think that what we have read so far, I have not heard one thing that's not petitioning activity. Despite what they want to call it,
certainly haven't seen a conspiracy.
They've pled themselves out of conspiracy in my mind.
Music to my soul, but will the discovery in this case really be much different from the other civil cases already being litigated amongst the same groups of people? Yes and no. I mean, there's going to be different stuff. Like for the defamation claim, it's going to be a completely different trial.
This gets them every. I can't remember what the other.
Music to my soul. What I need people to understand is truth is an absolute defense, and it's a burden shift in this case. When you're coming with defamation and the defense is saying, okay, well, you know what? It's fucking true. You did it. And so then the burden shifts over to the plaintiff to prove that what they're saying, what they claim is defamatory, is false. So it's a burden shift. They are going to literally retry the Karen Read case. That's literally what's going to happen, except this time the defense is going to have no bars. Like all the things that Kearney was doing, like making them get, like in trial one, when they wanted to get the third party culprit stuff and she made them go through Bowden to get it in. If you guys will remember, that was a ruling. She's like, I'm going to let you try to get it in through Bowden and the state's case in chief. And Bowden is talking about awful investigations, police investigations, that it was inadequate, and as a result of that, that's how she was going to let it come in. Now, what Lally did is he did a pre-Buttle case. He put on their entire case without them even having to do the Bowden thing. I mean, they still did some of the Bowden stuff because the investigation was that bad. But the reality is Lally did him a huge favor, depending on how you look at it. But he put on their entire case to try to get in front of it.
Can you pick up on our, what is it, consumer fraud business practice thing where you read this person's name and thank them for paying us money for 27 months?
Wait, what?
What's the count? Something business. What the fuck
are you talking about?
This is what I'm saying. This is like their whole unfair business practices include the scheme of Turtleboy of reading off people's comments, personally thanking them
for a membership for 27 months.
Yeah,
exactly. Thank you for contributing to our scheme. We really appreciate that. Oh, honey, I am that Gigi. Became a YouTube member. Oh, family hug
for contributing to our unfair business practices.
Gifted 5 DD podcast memberships. Thank you very much. We appreciate you helping build the fam. Appreciate that so much.
Donnie Not Wahlberg became a YouTube member. I guess I just seen you around so much. I thought you were one, but thank you.
She's been on and off. Thank you, Donnie.
Appreciate it. I always enjoy you too. Thanks.
Vaughn 4. Appreciate you so much.
I just need to have cheaters at all times.
Yeah, I mean, it's time. Like we can't deny it.
I can't even keep track of them though. The fact that Norfolk Court had to implement a buffer zone that is still being litigated proves Norfolk proves Aidan was petitioning. Yes. Indeed.
I did music to my soul. Thank you for that.
Again, music.
JPJH, we appreciate you. Music to My Soul, we appreciate you as well.
JPH came back again.
Yep. Still don't get how this was not a countersuit to Karen Read's case against them that they removed to federal court. It's a good question. I mean, that one was getting clunky as it was. Like the judge had long thoughts about allowing Read's countersuit, if you'll remember, because that case is where the O'Keeffes are suing. Karen then turned around and countersued, and the judge had long thoughts about severing those cases because of just the enormity of them. So, and I can think of other reasons because they didn't want it to be anywhere near that case. They wanted.
I'm sure there'll be a countersuit now because she want to sue all these people and didn't because they weren't parties or something.
Yeah, I mean, I'm assuming. Well, no, she did sue the House defendants.
Oh yeah, they're the House defendants.
Yeah,
I can't keep track.
Thanks, JP. We appreciate you. Cigarette Hush gifted 5 DD podcast memberships.
Thanks, Cigarette.
Thank you so much for all the new family members. Don't BH 8N1.
DoorDash fun.
Oh, don't be hating. Thank you. I did it.
That's great. That was a good one.
Phew.
DoorDash fund. We could have DoorDashed. That's true. That required like thinking and, coordinating amongst ourselves. We're not able to do because I got starving as soon as we sat down here. Oh my God. I can't believe it's been 3.5 hours.
I know. It's been a long run. Mimi 2G.
More DoorDash fun to eat, Ali. Thanks, guys.
From Canada. We love our Canadian neighbors. Thank you so much. Aura. Anyone else connecting this to the YouTube psychic being found guilty for millions in the Brian Koberger professor case?
What is that about?
There was some TikToker that kept accusing some professor of being the murderer in the Koberger case, and that person won. The professor won a huge suit against a TikToker who probably doesn't have a pot to piss in.
Really?
Yep.
That's crazy. I guess that's when it goes to show, like, how could they disprove?
I mean, one thing that I could say about
psychic ability,
there was no petitioning activity going on there at all. That was just a person on a YouTube channel flat out calling somebody a murderer without knowing any of the real facts.
How could they prove that she wasn't actually psychic, or at least believed she was psychic?
I don't know.
I mean,
sounds like a good live for you to have with that psychic, though. You should put that thing together. Thank you so much.
Thank you.
So Boris 143 started Buried. Thank you so much. 10 out of 10 recommend. Hot take: this is a waste of time. It's not going anywhere. It's a delay tactic, not a real lawsuit. Delay for what purpose, though? The depths, I think it's a punishment. I think it's punitive. I really do. The deposition should be interesting, but it's such a massive miscalculation on their part.
Yeah.
All they've done is just guaranteed 3 more years of Aidan getting paid
to do this, to talk about
exactly this shit. Where like every single deposition is going to be Turtleboy Saturday night.
I mean, he's already facing a lot of prison time. I don't know why they felt this was helping. Like, and they're trying
to pile it on. I'm telling you, it's punitive for them. It's like, it's the only thing that
I almost think that they were just like, we don't care how stupid the claims are that we're going to lose. We want our side on paper. Like, we want it in the court of law. We want it written down and said for the world.
I think they just want to punish. I really do.
But like you said, then they're just stupid for not realizing.
Well, their attorney didn't tell them what these depositions are going to entail.
No, but like you said, they're paying for his defense. So where's the punishment?
I don't know. They must not have gotten sold on the anti-slap. Their lawyer must have told them, we'll beat the anti-slap.
Even if they do, like you said, he's getting paid to talk about it.
For years. Years. This is going to last years. Beautiful Messy Ball. Thank you very much. Excuse my ignorance, but who is Natalie? Natalie is the intermediary. If that was, I'm sure that got answered in chat, but that's the intermediary that was allegedly getting text messages from Karen and then passing them on to Aidan.
I think she's the only woman that we know says Amaze balls sauce. That's
And
who
who
Natalie
says
is.
that Karen says it? Where is Bobby Boy? Love you, Ali. I was downstairs getting food. Thank you, David James. Appreciate you.
Love you. back.
JP back again. They filed this right before the 3-year statute of limitations was about to expire. They're desperate. Well, I mean, desperate or not, if the statute runs, you're fucked. You know, I mean, it's like they had to.
You know, they've been through numerous lawyers. They didn't wait until they like, I don't know how they hooked these lawyers. I do not know.
Thanks, JP. Roosevelt Media News, $5. Please go on. I'm loving this. Please.
Oh, good. I'm glad you guys are enjoying it.
The beautiful, lovely mod, Brian, thank you so much. Gifted 5 DD podcast memberships.
Thanks,
We
Brian.
adore you so very much.
Hope you're keeping your doors locked.
DP Max Effort join today. Oh, yay. Thank you. I'm loving every second of you guys, of your guys' breakdown. You gained a new fan. Yes.
Oh, great.
So much. We love hearing that. Thank you. Thank you. Thank you. RMS Mass Injustice gifted 5 DV podcast memberships. Thank you, RMS. We appreciate that so very much, helping us grow the family. Kat Randall, member for 7 months. Thank you for all you do. Thank you for supporting the show consistently. We really
Thank
appreciate
you.
it. Anna Delvey. Is it the Anna Delvey? Wasn't the woman with the show, like who like came up
No.
with this whole
was like-
socialite?
It was an Anna something, but I don't think it was Delvey.
You
But
sure?
I could be. I'm not sure, but it doesn't sound right.
Seems like that's it.
Mm.
But at any rate, thank you, Anna Delvey, if that's really your name. Loomis Fit in the Woods. The sad part is, this is that there is still no justice for John. Here,
True.
here.
Somebody really needs to catch that owl pig slap.
Yeah, or that slick piece of ice that he slipped and fucking busted his like
And that stray, what's it called?
coyote.
Coyote.
Yeah. Petition to deprive Ali of food more often because she gets feisty. as fuck. Thank you, Sarah. Anna Delvey came back with another $2. Thank you so
Thanks,
much.
Anna.
NS Nancy, member for 10 months. You two are such good teachers. Thank you. Thank you, NS Nancy. We
okay.
appreciate that. Roosevelt Media News 501, $5. We are loving this. Please go on.
Thank you.
Thank you. And then Roosevelt came back one more time. People watch and follow Turtleboy because he is a human train wreck that shares it all openly. Truth.
Yeah.
Truth.
Yeah. It's
He leaves no stone unturned. He bears his soul. Kat Randall, and thank you, Roosevelt. Gifted 1 DD podcast membership. Thank you so much.
thanks,
I'm
Kat.
sure the person who received that was thankful as well. Sue LW65.
It's probably Sue.
Aw, family hug. No, like
Welcome,
you
Sue.
pop up for that. Up top, pop it.
We did that one. Thanks again.
Thanks. Kelly, WFH juror, member for 10 months. Happy to be part of the Griff Scheme.
Thanks for your
You're thrilled
continued
that you are
support.
as well. Thank you. And then Sleepless Sleuth, member for 13 months. I
Wow.
love being part of this scheme.
Aw,
We love that you guys are part of the scheme as well. And
thanks
then
for your
our
continued support.
dearly angel, Kim, sent us a $25 Venmo. And I got a couple of cash apps. Let me shout those out real quick.
I'm kind of feeling bad on this scheme we've been running on poor Kim every day.
I mean, Kim's the queen schemer. Nancy
This is unfair
says,
business
for great
practice.
chat. Love you guys. Thank you so much for that $10 cash app. We appreciate that. And Dr. Russell's gasp. I think yesterday I didn't give you the love. You sent a $20 cash app and said for keeping it about due process. Thank you. We appreciate you as always, our dear friend. All right, y'all. So I'm aiming for tomorrow. We'll see if I can talk Ali into it. I'll probably be able to drag her away from her shit for a couple more hours and knock this thing out. But we love you so much, mods. We appreciate the hell out of you. Thank you for working on a Friday night when you could have been out getting down.
Getting down.
Oh yeah. Oh yeah.
Get down on it.
So thank you. Perpetually. Thank you, Tracy. Thank you, Mandy. If you're out there, we love you. It's good to hear from you today. We've been missing on you. And to you guys, our beautiful, beautiful community. We love you so very much. Old or new, it matters not. We adore all of you because without you, I'd just be an old man
Sitting around talking to his wife.